Chief Justice of the Republic of the Philippines and the Associate Justices of the Supreme Court of the Philippines. Hear ye, hear ye, hear ye, all persons having business before the Honorable Supreme Court of the Philippines shall give their attention, for the court is now in session.
Call the petitions. Report.
Your Honors, good afternoon. This is a continuation of the oral arguments of the 37 consolidated petitions assailing the constitutionality of Republic Act 11479, the Anti-Terrorism Act of 2020.
Appearances.
May I request the representing counsels to make your respective appearances?
Good afternoon, Chief Justice, Your Honors. I am Attorney Jose Anselmo I. Cadiz, Counsel for the Integrated Bar of the Philippines and its Board of Governors in GR number 253124, Your Honor. Thank you very much.
May it please the Court, Attorney Theodore Te for the Free Legal Assistance Group representing the petitioners in GR number 252741. Ready, Your Honor.
Good afternoon, Your Honors. Alfredo B. Molo III, appearing for petitioners Justices Carpio and Carpio Morales and UP Law professors in GR number 252736. We are ready, Your Honors.
Good afternoon, Your Honors. Evelyn Ursua, representing the petitioners, NUJP and others, in GR number 252747. We're ready, Your Honors.
Your Honors, Ed Silagman, same appearance for the petitioners in GR number 252579. Thank you, Your Honors.
Magandang hapon po. Nery Colmenares for petitioner 252585, Your Honors. Thank you.
Assalamualaikum, Your Honors. I'm Attorney Algamar Latif. I'm appearing for GR number 252759. We are ready, Your Honors.
Good afternoon, Your Honors. Respectfully appearing as counsel for the respondents, Assistant Solicitor Generals Marisa de la Cruz Galandines, Rex Bernardo L. Pascual, Raymond I. Rigodon, State Solicitor Eduardo Poquis Jr., Associate Solicitor Kyle Brian Guerrero, and yours truly, Solicitor General Jose Calida, Your Honors.
Respectfully appearing, Francis Ardalesa, amicus curiae.
Okay.
Your Honors, good afternoon. Respectfully appearing, Francis Ardalesa, amicus curiae.
Thank you. This is the continuation of the interpellation by Justice Hadian. You may now proceed, Justice.
Thank you, Mr. Chief Justice. May I now call on Professor Molo.
Good afternoon, Your Honor.
You may remove your mask. Thank you. Good afternoon, Professor Molo. May a court of law review the factual basis for the issuance of a detention order by the ATC?
Yes, Your Honor, if there
Yes.
is a grave abuse of discretion, Your Honor.
In what action or actions? In what specific action or actions?
Your Honor, if there's a Rule 65 petition, Your Honor, I submit.
Right? Necessarily, the court hearing the case is duty-bound to review the evidence, information, or data in the possession of the state, which the ATC used or relied upon in issuing the detention authority.
Yes, Your Honor.
Yes. And because this evidence, etc., involve acts of terrorism brought to the ATC for determination, they are, at that point, and even thereafter, unless declassified, remain to be highly classified state and military secrets affecting national security.
Yes, Your Honor.
Yes. Therefore, they fall within the category of executive privilege, which is beyond judicial scrutiny. Almonte versus Vasquez, Chavez versus PCGG, as cited in Neri versus Senate, and Padilla versus Congress, involving freedom of information.
Yes, Your Honor.
Yes. So how do you think the security of our country and our people will get affected if and when the disclosure of highly classified state and military secrets affecting national security is judicially compelled?
Thank you, Your Honor. I believe there is a balance that we can strike, Your Honor, between national security and the need for anyone accused, especially if the penalty is life imprisonment without possibility of parole. We can, Your Honor, strike a balance and find a way for any of the accused under this law to be able to have an effective defense and certainly not keep the information he may need to defend himself away from him.
So you have two conflicting interests: the interest of the individual suspect on one hand, to specifically to his unrestrained liberty, that will only last for 14 to 24 days at the most, with all the safeguards installed by the law. On the other is the safety of our country and the safety of the Filipino people, including our children, who may just be instantly eradicated from the face of the earth if this information get into the hands of terrorists. So which one are you going to choose? The one involving individual liberty on one hand, or the national security, the safety and the very life of our country and the lives of our Filipino people?
Thank you, Your Honor. My answer, Your Honor, would be that under our constitutional order, it is possible to fight a national security concern and yet still maintain respect for the rights of people.
Mr. Counsel,
Yes, Your Honor.
Professor, my question is straight, so I expect a straight answer. It's clear. Which one are you going to choose? You can't choose both. You have to weigh. On one hand is individual liberty. On the other is the life, the security of our own country and our people. Which one are you going to choose under the circumstances already stated?
Yes, Your Honor. And my answer is, In fighting a fire like terrorism, we do not throw the baby out with the bathwater. We preserve our constitutional order by being different from terrorists. And because we don't, we end up making them win. We are no different from the lawless elements that we are fighting.
All right, so I would take that to mean that you favor individual liberty over the security, the life, the very survival of our country and our people.
Your Honor, my father is a soldier who fought in Leyte, the jungles of Sulu, who saw his fellow soldiers die at the hands of the NPA. I will never favor terrorists. But my father and my lolo, who was a police chief, who kept Bicol free from the NPA, also taught me, in waging a war, we cannot afford to lose the hearts and minds of our people. We cannot afford to lose our constitutional values.
All right, very well said, but it does not change the clear choice that you have made. And actually, I will agree with you fully if you will change your answer. All right, so let us go to the composition of the ATC. 8 of these members are alter egos of the president.
Yes, Your Honor.
Okay? At least 3 of them are members of the bar who have been known in the legal profession to be learned in the law, even before they joined the government service. We cannot undermine their expertise in the field of law, nor the expertise of the other members in finance, national defense, governance, information and communication technology, and money laundering. Would you agree, Professor?
Yes, Your Honor.
Yes. Do you think ATC will act justly and fairly on every application for detention authority filed before it?
Under the presumption of regularity, Your Honor, yes.
Very well. So they are public officers tasked to perform their respective duties under the law, and as such, they are entitled to the presumption of regularity in the performance of their respective duties.
Yes, Your Honor.
So I would take that to mean that you respect and
yes, Your Honor.
expect the ATC to properly discharge its functions
Yes, Your
in
Honor.
processing the applications for detention authority.
I hope so, Your Honor.
Very
I certainly respect it.
All right. There being only one ATC to process all the applications for detention authority, the probability that it will hand down conflicting decisions involving the same facts or circumstances is nil. Don't you think so?
I believe so, Your Honor.
Yes, very well. So, would you also agree that the creation and involvement of the ATC in the filtering, evaluation, and resolution of applications for detention authority is also an effective means to protect innocent people against possible abuses of unscrupulous law enforcers or military officers?
I certainly hope so, Your
Yes,
Honor.
very well. Why does the law require that every detention authority issued by the ATC be promptly reported to the judge of the court nearest the place of apprehension and the Commission on Human Rights?
To inform them, Your Honor.
Not only to inform them, but for accountability, for transparency, and close monitoring to ensure that the human rights of detained suspects are safeguarded. Okay. In resolving an application for authority to detain, can the ATC deny it?
Yes, Your Honor.
Yes. Can the ATC approve it?
Yes, Your Honor.
Can the ATC defer?
Yes, Your Honor.
Yes? In other words, the mere filing of an application for detention authority does not automatically mean it will be granted.
Yes, Your Honor.
Yes. In case of an application to extend the period of detention from 14 days to another 10 days, does the law impose any requirements?
Yes, Your Honor.
What are they, Professor?
One of them would be, Your Honor, that there is a statement that it is necessary to secure the evidence, Your Honor.
That is one.
Yes, Your Honor.
What is the second?
I forgot the second one, Your Honor. Sorry.
There are only three.
Yes,
All
yes, Your
right.
Honor. Unfortunately, I cannot recall the second and third one.
Yes. To prevent the commission of another terrorism.
Yes, Your Honor.
And third, that the investigation, the police officer, the law enforcer concerned, or the military officer concerned must guarantee that the investigation is being conducted properly and without delay. So again, what possible actions may the ATC take on these applications to extend? Can it deny?
Yes, Your Honor.
Yes. Or can the ATC approve?
They can also.
Yes.
approve, Your Honor.
Now let's go to wiretapping. You have an objection.
Well, I believe wiretapping is covered by my co-counsel, Your Honor, but I can try to.
Yes, please do.
Yes,
I
Your
think you can try your best.
Yes, Your Honor.
All right. Because I haven't had enough of you yet. All right.
Right, Your Honor. I'll do my best, Your Honor.
Yes. I think it is your clients who said this, that the position that wiretapping, with respect to the conversations that may be wiretapped, is overbroad and make no distinction as regards the matters or conversations to be tapped, whether related to terrorism or otherwise. I think it was former or retired Senior Associate Justice Antonio Carpio who raised that.
Yes, Your Honor.
Yes. And you are the counsel.
Yes, Your Honor.
Yes. So I do remember.
Thank you, Your Honor.
Okay. So so you are actually complaining that why is it there's no distinction on what to wiretap and what not to wiretap, all right? In reality, is there anyone wiretapping expert who can foretell that on the exact given time, place, and date, the party subject of wiretapping will definitely talk about terrorism and nothing else on the phone?
No, Your Honor. No one can predict what will happen in the future.
Yes. So it is not correct to say that
Well, Your Honor, I believe
in wiretapping you can discriminate as regards the time, the place, or the date when the people concerned will talk about terrorism. All right? So is the prohibition against wiretapping absolute?
No, Your Honor.
Okay. What does the law say?
Well, Your Honor, what we were saying, we were referring to Dicini versus Secretary of Justice, that if we are going to use technology in order to enhance our surveillance and wiretapping capabilities, we must make it narrowly, and so that the right to privacy of certain people will not adversely be affected.
Yes, but that is not in the law. What is in the law is no to wiretapping except when it is so allowed by the court. And in this case, which court has that authority to allow
The
or
Court of
to
Appeals.
grant the permit, all right? And the same rule also applies whenever they seek to surveil or freeze the accounts of suspected terrorists, right?
Yes, sir.
Yes, all right. For your information, 11 of us here sitting before you, we came from the Court of Appeals.
Thank you, Your Honor.
We can personally and with all honesty certify under oath, under the oath of our office, that the presiding justice and associate justices of the Court of Appeals possess all the qualifications, and none of the disqualifications prescribed by law for appointment to the Court of Appeals. Among their qualifications are proven competence, integrity, probity, and independence. Now, like the ATC members, would you agree that they too enjoy the presumption that they will regularly perform their duty in accordance with law and the evidence?
Oh, definitely, Your Honor.
Yes, very well. Now, on mundane things, I think it was also the petitioners you're representing who raised the objection involving mundane things. It is the position of the petitioners that Section 3E of the ATL on material support is overbroad because it can be interpreted as including even mundane things. Professor,
Yes,
what
Your Honor.
exactly are mundane things?
Well, Your Honor, we were referring to the phrase in Section 3E that says, any property, tangible or intangible, or service. So that's everything almost under the sun, Your Honor.
All right. Can you cite examples of mundane things?
Your Honor, for example, under material support, it would be punishable for a parent or a godparent to give allowance or deposit in the ATM of a UP student who has already been detained as a terrorist. That would be material support kasi nag-deposit ka sa ATM. Alam mo namang aktivista yung apo mo.
All right. It depends on the evidence.
But that's what the law says, Your Honor.
Material support is intended to commit terrorism. Now, please tell me which of the things I will mention is mundane.
Oh,
All
yes,
right?
Your Honor.
A roll of tissue,
Yes, Your
a
Honor.
pair of boxer shorts.
Yes, Your Honor.
Yes, mundane. The iconic isaw of UP,
Yes, Your Honor.
mundane.
Yes, Your Honor.
I will be very sad.
Oh, well, it's very special, Your Honor.
Yes, all
It's
right.
only available there.
Oh, Professor, I really respect your opinion and you have my full support on that. All right.
Thank you, Your Honor.
But may I ask,
Yes, Your Honor.
if A manufactures rolls of tissue paper, which he sprays with poison, and distributes them to supermarkets to instantly kill people who buy and use them in their respective washrooms, bedrooms, or even offices or kitchens, will these things be still mundane in our eyes?
No more, Your
All
Honor.
right. If A owns a poultry and distributes the innards of the chicken sprayed with poison to the isaw vendors in UP, precisely for the purpose of killing the isaw fanatics and mass like me, all right, will the isaw still be mundane in our eyes?
No more, Your
All
Honor.
right. So would you agree that the more mundane things or objects seem to be, the more likely they will be used as mediums for terrorism, like the slaughter of innocent people?
Yes, Your Honor.
Yes. The reason is simple. Would you like to cite the reason or I'll cite it for you?
I would defer to Your Honor.
All right. Very good. Thank you. Okay. People in general tend to be unmindful and unsuspecting of the so-called mundane things or objects. We tend to take them for granted, but because we think they are harmless and innocent. But these things are precisely what terrorists are looking for.
Yes, Your Honor.
So, Professor, for my last question, I will tell you a story about Captain Ree.
Oh, yes, I know him, Your Honor.
Really?
Captain Ree, Your Honor. Yes.
Yes. An officer of the Armed Forces of the Philippines. Do you know him?
Oh, no, I thought a different Captain Ree, Your Honor.
With posting at Metro Manila.
Oh,
All right.
a different Captain Ree.
Today, he receives a call from an anonymous person informing him that an hour from now, 5 identified hospitals for children in different parts of the country will be blown up by 2 bombs planted in each of these hospitals. The one person who will detonate these bombs all at the same time, an hour from now, is an IT genius staying at a residential house on Raven Street inside the Blue Valley Executive Village in Cainta, Metro Manila. All he or she needs to do is touch something on his or her cell phone to cause the deadly explosion. At this very moment, that person is staying put in that residential house to synchronize his or her actions with his or her co-conspirators at the exact appointed time. My question, what do you think Captain Rhee should do after receiving the information from the anonymous caller?
But certainly, Your Honor, he should exhaust what is available under the ATA to stop the terrorist act from happening.
So will you tell us specifically what remedies he ought to exhaust if you were Captain Rhee?
I would go to the venue that was conveyed to me, Your Honor.
Alone?
No, Your Honor. I would bring other people, other armed elements with me, with
Then
law
what will you
enforcement
do
unit.
there?
And we will, of course,
You
Your
will
Honor,
go to all five? All at the same time?
well, depending on the resources available, but I understand the difficulty being faced by the Honorable Justice, Your Honor.
Yes, it's really difficult.
Yes, Your Honor.
So on the ground, Captain Rhee has to make a decision, a
Yes,
quick
Your Honor.
one, and based on what he thinks is the best remedy. All right?
Yes, Your Honor.
Oh, can I tell you what I will do if I were in his place?
Of course, Your Honor.
Yes. So I will immediately summon my people to evacuate all the children and everyone inside the hospital. At the same time, I will summon bomb experts to defuse the bombs right off. I will also dispatch my people to secure all the houses situated on Raven Street, restrain them, and confiscate their cell phones and other gadgets. Then I will apply for a detention authority. Since I cannot yet determine who among these people is the IT genius assigned to detonate the bombs, I will need time to investigate. Meantime, I cannot take the risk of releasing any one of them until I shall have on hand sufficient information or data to identify with specificity who is the IT genius and his or her conspirators. So I also need time to look for that anonymous caller and convince him or her to come forward as a witness. So that would be my actions under the circumstances if I were Captain Rhee. Do you think my actions are correct?
Your Honor, they're more than correct. They're
Very
actually very
good.
proactive.
So
and it would save
excellent.
a lot of lives.
All right. So in closing, Professor, allow me to say this. Unlike the fictional character of Captain Rhee, you and the rest of your team are true-to-life patriots. Congratulations and thank you for graciously responding to my questions. You may now take your seat.
Thank you, Your Honor.
pleases you.
God bless you.
So with that, Mr. Chief Justice, I've concluded my interpellation. Thank you, Mr. Chief Justice.
Thank you. Justice Radil Salameda. Okay, please go ahead.
Thank you, Chief. We haven't heard from Attorney Cadiz yet. Can I call on Attorney Cadiz? Good afternoon, sir.
Good afternoon, Justice. Just to clarify something, I spoke during the first day of our oral argument.
So that's good. Nobody has asked this question yet, as the answer may be obvious to many. Is there really a need right now for the Philippines to have an anti-terror law?
Your Honor, in my very humble view, the Human Security Act is enough, Your Honor. Deter terrorism.
So you are
Your
saying...
Honor,
Okay.
if I may clarify.
Please continue.
What is really lacking is good police work and good intelligence work. I think these are sorely lacking in our jurisdiction.
So your position, counsel, is that for the total scrapping of the ATA?
Your Honor, my view and the view of the rest of the petitioners is that the anti-terror law is void ab initio, Your Honor.
Okay. Between 2001 and 2018, at least 140 governments have already adopted counter-terrorism legislation. Do you agree that because of the continuous threat of international and domestic terrorism, it is better to have an anti-terror law than nothing at all? Counsel.
Your Honor, I agree with you that many countries have adopted their anti-terror laws. However, I always juxtapose our laws with what the Constitution requires. Many countries in the world don't have their Bill of Rights as part of the Constitution. But in our Constitution, Your Honor, that is the bedrock of our liberties. So, always, Your Honor, as men of law, we must always adhere to the Constitution, and any law which contradicts the Constitution must be struck down. And that is what the anti-terror law is all about.
What do you understand by the famous aphorism that one person's terrorist is another person's freedom fighter?
Your Honor, in college, I read that. One's bandit is another's revolutionary. But I don't think the terrorists who decapitate people in London Bridge, who attack people in the trains from Belgium to France, can be considered revolutionaries. They are plain terrorists, Your Honor.
We agree to that, Counsel. Now, do you agree with me when I say that the concept of terrorism is fundamentally political in nature?
No, Your Honor. Many terrorists are plain criminals, Your Honor. I don't think a terrorist should be classified as a revolutionary. It gives revolutionaries a bad name, Your Honor.
Is it not that until today, the international community has yet to adopt a comprehensive and universal definition of terrorism, Counsel?
I agree very much, Your Honor.
Okay. And because of this lack of a comprehensive and universal definition thereof, the politicization and misuse of terrorism has been abused by states to curb non-terrorist and even non-criminal activities. Am I right?
Yes, Your Honor.
Is this exactly the same fear you have right now, Counsel?
Your Honor, it is not fear because many features of the anti-terror law are plainly unconstitutional.
Okay.
It's beyond my personal beliefs, Your Honor. It's about the law being unconstitutional.
Because it redounds to a lack of proper definition of terrorism. In fact, the entire international community has different definitions of terrorism, Counsel.
Yes, Your Honor, I agree.
Is this not merely a problem of enforcement and implementation of the anti-terror measures, Counsel?
I don't agree, Your Honor, because, for example, it has been repeatedly discussed in the past days about the 24-hour detention period without warrant of arrest. This is really abhorrent, Your Honor, to the Constitution.
So you are saying now, Counsel, that anywhere in the world, the definition of terrorism is unsettled. And any anti-terror law cannot be the basis for legal adjudication because of the vagueness and being overbroad. Am I right?
It is overbroad and it's vague, Your Honor. I agree.
Now, Counsel, do you know that our own ATA's definition of terrorism under Section 4 was patterned after the anti-terror laws of Australia, Malaysia, Thailand, and Sri Lanka? That's according to the sponsor of the law, Senator Panfilo Lacson.
Yes, Your Honor. But
Okay.
precisely, Your Honor, if you look at the constitutions of these countries, they don't have their Bill of Rights, Your Honor.
Do you also know that there are no substantial differences with our definition and the definition of terrorism in the anti-terror laws of United Kingdom, United States, Canada, and even Russia? Do you know
Yes,
that?
Your Honor.
You agree? Of all the anti-terror measures in the world you have come across with, what do you think is the most ideal anti-terror law of any country, Counsel?
That is a very difficult question.
Any
to
wild
answer.
guess?
But,
The US?
Your Honor, it really depends on the setting of the anti-terror law.
Okay.
And I believe there is no comparison and there is no anti-terror law applicable to the country, Your Honor.
Do you know in every country that there is an anti-terror bill or an anti-terror law? All of those countries, all of those laws have been questioned in their respective jurisdictions for being vague and overbroad.
Yes, Your Honor, and they have even been brought to the United Nations, Your Honor.
Okay. Can you tell me whether or not an anti-terror measure in any countries was declared unconstitutional by any jurisdiction?
Your Honor,
I'm just asking you if you know any country which declared its anti-terror measure, Counsel.
Your Honor, I'm not very familiar.
You're not familiar
But
with it?
then some countries have already moved to amend their anti-terror law because they have created criticisms from many sectors like the European Union, the Commonwealth group of countries, and even in the United States, Your Honor.
So of the, I think, 140 countries which has adopted anti-terror measures, none of those anti-terror measures have been declared unconstitutional or invalid so far.
I'm not aware, Your Honor, but then again, they will not have the Bill of Rights that we have in this country, Your Honor.
There is one here, the anti-terror bill of Indonesia. It was declared unconstitutional. Why? Because of the retroactivity clause and not because of the substance of the law. Okay? Because according to the Indonesian Supreme Court, it was precisely made to apply and passed to apply for the Bali bombings of 2002.
In Bali, Your Honor.
Yes,
Your
in
Honor.
Bali, Indonesia. We go now to another question, Counsel. If you are given the authority by the international community to craft the definition of terrorism in your own words, can you give us a comprehensive and universal definition acceptable to all, which should pass your criticism of being vague and overbroad? An ideal definition that is being espoused by the petitioners here for terrorism so that it can be adopted by the United Nations.
I will not have that kind of capability, Your Honor. I am a small dust in the firmament of the legal community all over the world.
So, thank you, Counsel. Isn't it that the UN Security Council resolutions and other relevant international conventions, protocols relating to terrorism can guide the courts in its proper adjudication of what terrorism is? They
Your
are
Honor,
guidelines for the definition of the court in what terrorism is.
Your Honor, I believe in international law. It may not have the enforcement capability, but the will of and the opinion of civilized nations in the world are very, very persuasive.
So this is precisely the ruling of the Supreme Court of Canada in Suresh versus Canada, a 2002 decision where the Supreme Court of Canada ruled that the term terrorism is not inherently ambiguous, even if the full meaning must be determined on an incremental basis as the concept is continuously evolving. Do you agree to that?
Yes, Your Honor.
Now, the UN, pursuant to Security Council Resolution 1373 cited in the ATA, calls upon states to become parties as soon as possible to relevant international conventions and protocols and so on relating to terrorism. Is the UN Security Council Resolution 1373 cited in the ATA as a source of a binding obligation for UN member states?
Your Honor, I believe that municipal law must prevail over international conventions.
But we are parties of the United Nations, and under Article 48 of the UN Charter, the action required to carry out decisions of the Security Council for the maintenance of international peace and security shall and should be taken by members of UN.
I agree, Your Honor. However, as I said earlier, the Human Security Act is enough law to be able to combat terrorism. And I go back to my thesis that what should be encouraged, what should be strengthened is good intelligence work and good police work.
Now, Counsel, you are saying that the HSA or the Human Securities Act is a better law than the ATA because it states therein the predicate crimes to constitute terrorism. Am I right? One of the reasons why you say it is a better law.
Yes, Your Honor. The predicate crimes are enumerated.
But would this not restrict the prosecution and deterrence of terrorism if you state the predicate crimes?
I don't believe so, Your Honor. But let us put this in a proper context. We all live in an imperfect world. There will be imperfections. We cannot guarantee a terror-free country. No country will be able to guarantee that, Your Honor. But in balancing our individual rights, as stated in the Bill of Rights, Your Honor, I think the Human Security Act, is the better law, Your Honor.
But you say that terrorism, the concept of terrorism is continuously evolving. If you state in the law the predicate crimes, how about in the future where a future definition of terrorism may encompass other acts or other crimes?
Your Honor, then the Human Security Act can be amended to include all those other predicate
What
crimes.
if such act were executed now when in fact we have already declared the Human Security Act as unconstitutional?
The anti-terror law, Your Honor?
No.
The Human
Right now.
Security Act has been declared constitutional.
Yes.
Your Honor.
No. I mean to say, when predicate crimes is not encompassed by the Human Securities Act because terrorism is continuously evolving. What happens now if there is such an act?
Your Honor, I could not, at this point in time, think of any other evolving predicate crime which is not covered by the Human Security Act, Your Honor.
Now, Counsel, does UNSC resolution, are you aware of USNC Resolution 1373?
I'm not aware, Your Honor.
Okay. The last paragraph of Section 4 of the law provides that terrorism shall not include advocacy, protest, dissent, stoppage of work, and the like. Is this provision not enough, a safety net for you in the exercise of civil and political rights, and why?
No, Your Honor. That is really a very minor exception in my view.
Okay. Do you know, Counsel, that this particular provision is also found in the anti-terror laws of Australia, Canada, South Africa, and New Zealand? And in fact, it was adopted from the anti-terror laws of these countries.
I have read some of the minutes of the Senate deliberations, Your Honor, and I agree. Those were inspired by the laws of other countries. But again, Your Honor, these countries don't have the Bill of Rights that we have. And Your Honor, I don't think we can compromise the sanctity
Meaning to
of our
say,
Constitution.
you're saying that Australia, Canada, South Africa, New Zealand has a different Bill of Rights from us? Are you saying that? The concept of
Your
Bill of
Honor,
Rights of these countries
our
are
Bill of
different?
Rights is really very, very ideal. It's
More ideal than Canada, South Africa, and New Zealand, Counsel?
Canada and Australia, Your Honor, adopt common law. So
How about the United States?
the United States, Your Honor, has a Bill of Rights.
Yes.
I agree.
And our Bill of Rights is more ideal than the United States.
Well, Your Honor, in some respects, but let us see how the United States deal with terrorism.
Okay.
It has detained indefinitely people in Guantanamo Bay,
More
which
than
is
the usual
outside the
number of-
jurisdiction of the United States.
Yes.
I think that is really abhorrent, Your Honor. Many detainees there have been incarcerated for the past 15, 18 years. And succeeding presidents of the United States have promised to close the detention facilities in Guantanamo Bay, but they have not done so. So, Your Honor, this matter of the United States speaking against terrorism is really not very ideal in my view, Your Honor.
What's the status of the anti-terror laws of the United States? Are they still valid and binding right now or declared unconstitutional?
I did not get your question, Your Honor.
What is the status of the anti-terror laws of the United States? Are they valid or constitutional? Or
At this point in time,
they are still valid and constitutional?
they are still valid, Your Honor.
Yes. Also, in the ATA, Section 2 particularly, it stated that in the implementation of the policy of the law, the state shall uphold the basic rights and fundamental liberties of the people as enshrined in the Constitution. Also, exercise of the constitutionally recognized powers of the executive department shall not prejudice respect for human rights, which shall be absolute and protected at all times. Can these provisions in the Declaration of Principles provide a useful insight into congressional concerns and objectives and help resolve any ambiguity in the ATA?
Your Honor, that is a very general statement.
Yes.
It is a motherhood statement. But if we look at the particular provisions of the anti-terror law, it really runs counter to that general statement that is found in that particular section.
But
Your Honor.
under the rules on statutory construction, counsel, if there is some ambiguity, the court can look into this declaration of principles for guidance. Am I right?
I agree, Your Honor. But why do we have to have an ambiguity, Your Honor, when we can be very clear about our position?
Because petitioners are saying that there are ambiguous provisions in the law, and in fact, the definition of terrorism is ambiguous and overbroad according to the petitioner.
I agree, Your Honor.
Okay. You know of inchoate offenses or inchoate crimes?
Yes, Your Honor, but I don't think that is a matter that has been adopted in the country. Because, Your Honor, there must be really an attempt to commit a crime. The intent is hard to discern, Your Honor.
Meaning to say that conspiracy to commit a crime is not punishable here?
Your Honor, there must be overt acts.
Proposal to commit a crime is not punishable here?
Unless there are overt acts, Your Honor.
Under the dangerous drugs law, under the comprehensive dangerous drugs law, these are inchoate crimes, but these are punishable.
I'm not familiar with the
comprehensive dangerous drugs law.
The drugs law, Your Honor.
So can inchoate crimes be penalized?
Your Honor, I don't believe that it can be penalized in our jurisdiction.
You have gone over the ATA, and there are inchoate offenses under the ATA. Am I right?
Your Honor, the ATA always speaks about intent. But the intent is just determined by the Anti-Terrorism Council.
I just want to enumerate the inchoate offenses under the ATA for your information. Now, Section 6, planning, training, preparing, facilitating the commission of terrorism is one. Section 7, conspiracy to commit terrorism. Section 8, proposal to commit terrorism. Section 9, inciting to commit terrorism. Section 10, recruitment and membership in a terrorist organization. Section 12, providing material support to terrorists. And 14, accessory to terrorism. Now, do you know the reason for the inclusion of these inchoate offenses in the ATA? Counsel.
Yes, Your Honor.
What is the reason for the inclusion of these inchoate offenses in the ATA?
Your Honor, I believe that it is simply to give a broader discretion to the Anti-Terrorism Council.
No, it is in deference to the requirements of United Nations Security Council Resolution 1373 and the other United Nations security resolutions. Now, can you give me the reason why, or the rationale why these inchoate crimes and offenses are being punished under the ATA or pursuant to the requirements of the Security Council resolution?
Your Honor,
it is for prevention and deterrence.
Ostensibly, Your Honor.
Okay. Now, do you want to have these inchoate offenses excluded and decriminalized? Because they are not part of the HSA. You want this to be removed from the ATA, these inchoate offenses, Section 6, Section 7, Section 8, Section 9, Section 10, 12, and 14?
Your Honor, I believe that there must be overt acts before one can be punished or one can be
Meaning to say
prosecuted.
that us will have to wait for some overt acts before we act to arrest a person who is committing or who is conspiring to commit terrorism, who is proposing to commit terrorism, who is inciting to commit terrorism, among others. We have to wait for an overt act that there exists already an act of terror.
Your Honor, I disagree with that premise, Your Honor.
So
Your
please
Honor,
explain.
as I said, with good intelligence work and with good police work, we can be able to prevent these things from happening.
So the matter really is with implementation. The problem is execution and implementation. You need not declare the law unconstitutional if it's a problem merely of execution and implementation. Am I right?
No, Your
Counsel?
Honor, it is not a problem of execution and implementation. It is a clash between this law and the Constitution.
Thank you, Counsel.
Thank you very much.
Can I, you may take your seat. Thank you.
Salamat po.
Can I ask either congressman about Section 29 of the ATA? This is just a follow-up on the questions of the Chief Justice last time. Kahit sino. Congressman Langban?
Yes, Your Honor.
Thank you, sir. Good afternoon. This Section 29 of the ATA, sir, on the preventive detention of a suspected terrorist, is this not merely an exercise of the plenary legislative power of Congress, creating an exception to Article 125 of the revised?
No, Your Honor. It's an abuse of discretion of the Congress because that would authorize an executive agency like the Anti-Terrorism Council to issue a warrant of arrest.
No,
because an authority to detain assumes that it is also a warrant to arrest.
I'm sorry, Counsel. I'm just referring to the extension of Article 125, the extension given by Congress. Is this not a legislative prerogative?
Yes, Your Honor, it is a legislative prerogative because we do not enact unrepealable laws or laws which could not be amended. But a law can only be amended if the amendatory law is constitutional.
Okay.
I would submit, Your Honor, that Section 29 is grossly unconstitutional because it violates Section 2 of Article 3 of the Constitution, which requires judicial warrant of arrest based on probable cause to be determined personally by a judge, not by an executive agency.
Congressman, can we consider this legislation a policy determination of the Congress, considering the unique nature, complexities, and repercussions of the crime of terrorism, which this court cannot intrude into in the absence of grave abuse of discretion?
Your Honor, policy determination is vested in Congress, but policy determination is circumscribed by the Constitution. And I would submit, Your Honor, that if a policy consideration of Congress, like Section 29, is an affront to the Constitution, then this honorable court can exercise judicial review.
What particular provision in the Constitution is violated by this extension of time as provided for in Section 29?
There are a number of provisions, aside from the fact that no warrant of arrest shall issue without probable cause to be determined by the judge. This provision should only which also violates presumption of innocence, the right to bail, to citizenly file bail, the right against torture, because this extended and prolonged detention would be inimical to the presumption of innocence, to the right to file bail, and also the right against torture.
Now, Counsel, one of the petitioners here stated that this Section 29 violates in particular Section 18, Article 7 of the 1987 Constitution. Do you agree with that?
Well, let me just refresh my memory about Section
During the
18.
suspension, I would like to refresh
Ah,
you.
yes, that's-
During the suspension of the
Yes.
privilege of the writ, any person thus arrested or detained shall be judicially charged within 3 days. Otherwise,
Yes, Your
they shall
Honor.
be released.
I now recall that Section 18 of Article 8 of the Constitution. And under that provision, once the privilege of the writ of habeas corpus is suspended, no person shall be detained for more than 3 days without being referred to the judicial authority. Otherwise, he should be released. And I would submit, Your Honor, that this would apply to all crimes, not only with respect to rebellion or acts relative to invasion.
Now, under Section 29 of the ATA, is the privilege of the writ of habeas corpus suspended?
Effectively, Your Honor, that is not suspended, Your
It's not
Honor,
suspended.
but effectively the right to secure habeas corpus can be effectively suspended or denied, because the police authorities or the ATC can always say that the person is being detained under the written authorization of the Anti-Terrorism Council, which is subject to constitutional challenge.
That's all, Congressman. Thank you.
Thank you, Your Honor.
You're through? You're through? You're through already? Okay, who's next? Justice Henry? Oh, Justice, okay. Justice Lopez? Yes.
Thank you very much, Chief. Congressman Lagman, please. Just,
Good afternoon, Your Honor.
just a few questions, Congressman. Pwede po ba hong Tagalogin na lang?
Yes, Your Honor.
Ito'y itinatanong sa akin nung pang nag-umpisa tayo ng oral arguments. Ang sabi nila, bakit si Congressman Lagman dumudulog sa Supreme Court, nasa Korte Suprema, samantalang ang batas na kanilang pinapawalang bisa ay kanilang ipinasa, pinagbotohan, nagdebatehan, at ang mayorya ay nanalo upang ipasa ang batas. Ngayon po, ang tanong ng ating mga kababayan, bakit ngayon nandirito si Congressman Lagman upang ipawalang bisa ang ating batas na kanilang pinagbotohan?
Unang-una po, kahit na pinasa ng mayoriya ang batas nito, ay hindi gusto sabihin na ito ay walang kakulangan at hindi ito labag sa saligang batas. Sapagkat yung mayoriya ay hindi tama all the time. At ako naman po, bilang isang independent opposition, ay noon pa ay hindi sang-ayon sa batas na to. At ako po ay nagbigay ng aking reservation na mag-i-interpellate doon sa mga sponsors. Ang sabi sa akin, pangatlo ako sa listahan. Ngunit natapos na lang po ang botohan, ay hindi po ako tinawag. Kaya nung ako ay nagboto ng negative vote, sinabi ko sa liderato ng mababang kapulungan, bakit explain ninyo bakit ako hindi nyo tinawag? Sapagkat ako ay hindi sang-ayon sa panukalang batas na ito. At gusto ko pong sabihin, Mr. Justice, na itong bill ng mababang kapulungan ay pinalitan, ginawang copycat ng bill sa Senado. Kaya ang nangyari po, wala nang tinatawag na bicameral conference committee sapagkat wala nang pagkakaiba yung Senado at yung version ng mababang kapulungan. Ano po, ako palagay ko na lang ang huling nasa Kongreso na miyembro ng bicameral conference committee nang sinabatas itong Human Security Act. Bakit po marami dyan na safety provisions, talagang protektado ang civil liberties sapagkat doon po nagkameron ng bicameral conference committee at marami po kami dyan na ginawang amendments upang makasama sa Human Security Act so that we can protect the people's right.
Salamat po, mahal na Congressman. Pero meron po naman kayong internal rules para suriin kung mayroong mga paglabag sa inyong mga internal rules, ay meron ding mekanismo upang ito ituwid. At pangalawa po, nandito po kayo sa aming hukuman upang balangkasin ang constitutionality ng ating terorismo batas. Hindi po kayo nandito upang questionin yung paglabag ng Kongreso sa inyong rules of procedure. Kaya po, ang tinatanong ng ating kababayan, hindi po ba labag sa konstitusyon na kayo ay nagsubmite ng inyong mga proposal, kayo ay nagbotohan, hindi po ba labag sa separation of powers na kami ngayon ay dumudulog sa inyo at ngayon there is an extension of your objection to the law before us?
Marami na pong kaso na nanggaling sa Korte Suprema na ang mga legislators ay binigyan ng personality para nga mag-file ng petition dito sa Supreme Court laban sa mga batas na sinasabi nila ay unconstitutional. Yan po ay karapatan ng isang legislador. Ito po ay susog lamang sa bagong power ng Supreme Court dun sa judicial review. Na nakasaad doon
Sandali
na
lang
pwedeng...
po, Congressman. Kasi po, kayo na po ay yung mayorya po ang nanalo. Sa ating konstitusyon, majority rules. Ngayon, nandito po tayo upang balangkasin ulit ang batas na inyong pinasa. So, hindi po maintindihan yon ng ating mga kababayan. Na meron po tayong mga kaso at pinag-aralan ko at nakita ko na ang mga kaso na yon, what is involved is your participation. It is not the constitutionality or validity of the law which is the subject matter of the case brought before us by the legislators.
Alam mo po, Mr. Justice, kung kayo po ay nasa mababang kapulungan ngayon, maintindihan po ninyo kung gaano kagarapal ang supermajority at hindi na nabibigyan ng boses ang minority. Kaya po, kami po dumudulog dito sa Korte Suprema parang ayusin ang sistemang yan at upang i-invoke an expanded judicial power of review ng Korte Suprema.
Kasi po, narinig ko si Professor Molo, binabanggit yung Baker versus Carr. eh baka naman itong mga sinasabi ninyo political issue na, purely political issue which the court cannot address.
Hindi po.
Hindi po, okay po, salamat po. I already mentioned my point. Pumunta na po tayo sa susunod.
Meron po lang gustong sabihin.
Sige po.
Hindi po political issue ang aming dinudulong dito sa Korte Suprema. Ito ay constitutional issue. Ito po ay paglabag sa ating saligang batas, particularly the constitutional rights provided for under the Bill of Rights. Hindi ito political, ito po ay justiciable and judicial.
Okay, salamat po. At sana maunawaan ng ating kababayan ang dahilan bakit kayo ngayon ay nandito. Pangalawa na lang po, and last point po ito. At the time you address this court, I heard you said that these constitutional rights are inflexible. Natandaan ko po yung word inflexible.
Hindi ko po maalaala kung yun ang katagang sinabi ko.
Yan po,
Inflexible.
sinulat ko po, inflexible.
Baka po that will be reading out of context.
Ang karapatan ng mga ito, ng mga tao, fundamental, which is constitutional in character, are inflexible.
Hindi ko po yata sinabi yan. Sapagkat alam ko po na ang mga karapatan nito ay hindi absolute.
Okay.
Ay pwede po ito bigyan ng reasonable limitation dun sa valid exercise of police power ng Estado.
Okay. So I will follow that point, Congressman. Since these rights that are restricted by the ATL, Anti-Terrorism Law, are flexible, meaning under one circumstance it is not valid, but under another circumstance it is valid. Tama po?
Opo. Depende sa sitwasyon.
Depende sa sitwasyon.
At depende sa provision ng batas.
At depende sa provision na batas. Kayo dumudulong dito at sinasabi ninyo na ito ay hindi dapat mangyari dahil ang sitwasyon ay ganito. Tama po?
Opo.
Opo. Ang Solicitor General of the State is also here saying that there is no violation because of a certain proposition or circumstance to validate that right which is restricted. Tama po?
Opo.
Magkasulungat po kayo, ang solicitor at kayo mga petitioner, magkasalungat depende sa sitwasyon or circumstances. Tama po?
Opo.
If that is so, meron po ba tayong issue about real controversy kung ito sinasabi nyo at ito ang sinasabi nila at wala pong real issue that will dispose the case and there is no person that is prejudiced, meron po ba tayong tinatawag na controversy as well as your standing before this court?
Doon po sa extended
kasi po, yun po hypothetical hula tayo, hypothetical, lahat tayo rito nagha-hypothetical eh.
Kung pwede po, tapusin ko na yung sagot ko, Mr. Justice.
Kasi hanggang doon na lang po ako eh. Hanggang doon na lang ako. Yun lang, kasi naintindihan ko na, hypothetical on your part, hypothetical on the part of the respondents, proposition that will validate the violation, proposition that will also respect the Constitution sa inyo against the So nagkakabanggahan ang different proposition or hypothesis. And what I am saying now is, if that is the case, wala tayong controversy.
Meron tayong controversy sapagkat nga salungat yung posisyon ng petitioner.
Exactly po.
At salungat dun sa...
Salungat din sila.
Opo. Kaya po may controversy.
Sa banda, ganito. Sa kaliwang banda, ganito naman. Nasaan ang controversy?
Ang controversy po yun sa salungat na posisyon ng dalawang panig. Kaya po mayroong Korte Suprema na ang Korte Suprema ang mag-resolve ng contending positions na to. Pursuant to its expanded power of judicial review. Maraming salamat po.
Salamat po, galang-galang na congressman. At tayo po ay nagkaliwanagan.
Excuse me, can I just ask one question kay Congressman Lagman because of his explanation about you just adopted the resolution of the Senate? Can the lower house and the upper house agree that the bill will no longer go to a BICAM to a BICAM? So is there a rule? Is there a rule where the BICAM can be excused?
Yes, Your Honor.
Yeah.
That is possible.
That is allowed.
That is possible, Your Honor. But we should look at the motive why
Yeah,
both
but,
houses
yes.
decided to have
I'm just
bills.
asking you the procedure because there may be a misconception that because according to you, the lower house just adopted without any deliberations, without any debate in the lower house.
Meron pong
Yeah,
ganito po ang history.
in this particular case or under your rule, if the lower house adopts in toto the Senate version, the version of the upper house, then it will no longer go to a BICAM because there's nothing more to debate in the BICAM because the lower house adopted in toto the version of the upper house. And this is what happened to this.
Yes, Your Honor,
Yeah.
because
And that has been done many times.
this has been done
Yeah,
even in the
so I
passage
think-
of the abolition of death penalty. This has been done.
Yeah, it has been done. So
But we should look into the process why it was done.
that's another thing. I'm just asking you about the procedure.
Yes,
if
Your
that
Honor.
if BICAM can be waived, and one of the instances is when the lower house adopts in toto the Senate version. So they do no longer go to a BICAM because there's nothing more to tackle in the BICAM because the lower house adopted in toto the version of the Senate.
Yes, Your Honor.
Thank
There
you.
was a malevolent motive
Yeah.
in copying the version of
Yeah,
the Senate.
thank you very much, Congressman. Thank you.
Thank you, Your Honor. Thank you, Mr. Chief Justice.
I am supposed to call on Dean Diokno, but he is not here, Dean Diokno. So who will take care questions that I will propound for the Dean? Oh, Professor Te, my good friend. Sorry if I have to call on you and explain to us. Kasi,
My pleasure, sir.
Professor Te, one of the statements made, preliminary lang po ito, is that the anti-terrorism law is mala prohibita. I heard that from Dean Diokno. Do you agree, Professor Te?
Thank you, Mr. Justice Lopez. Under our current system of classification of penal laws, Mr. Justice, there is a binary classification. One would be felonies or mala inse, as we know them, and the other would be special laws or malum prohibitum.
Ang tanong lang ko ay
Yes, po.
kung yan nga ay malum prohibitum.
Yes, Your Honor. May I be allowed to just...
Hindi ako mag-explain
Yes, sir.
ako pagkatapos mong sabihin.
Yes, Your Honor.
I will be the one who will explain.
Okay po. Under the circumstances, yes, it would be malum prohibitum.
Therefore, why is it malum prohibitum?
There is the intent, the mens rea requirement under the revised penal code is not required. It is dispensed with. In fact, the revised penal code does not apply, Your Honor.
So you are saying that since the terrorism law is a special law, then it is mala prohibita.
Yes, Your Honor. Effectively, the law prohibits specific acts without requiring criminal intent. Only the intent to perform those acts, Your Honor.
I understand and already settled in our jurisprudence. A special law need not be a mala prohibita. A special law may also be mala in se. What differentiates a special law is the morality, the intent that is involved in the commission of the crime. Dungo versus People is one, which said that a special law may be mala prohibita and mala in se at the same time. In the same way as the revised penal code, may also be mala prohibita and at the same time mala in se. Hindi po ba, Professor?
Yes, Your Honor, I do agree, except that may I just point out simply that under this particular law, especially Section 4, Your Honor, the formulation of Section 4 would make it more a mala prohibita because there are specific prohibitions, Your Honor.
Despite the several provisions mentioning about intentions, you do not agree that it is mala in se?
I do not, Your Honor.
All right. There were several things that were mentioned by the Dean and which somewhat make me think about my criminal law. For instance, crime of intentions. Crime of intentions. Sandali, Kwan, sandali. Crime of intentions ang terror law. There are general provisions and are not specific. Another one coming from Attorney Colmenares, even crimes of tendency are being penalized, including preparatory acts. Meron pang sinabi, assembly by itself, as long as it is peaceful, there is no crime committed regardless of the intent. And then, kanina narinig ko rin kay Attorney Cadiz, the old terrorism law is better than the present terrorism law. Siguro po narinig nyo kanina, sang-ayon po kayo sa lahat ng mga bagay na yan na aking sinabi.
Yes, I heard those statements, John.
Yes, you heard this. Now, pasensya na, Professor, at kailangan ko lang i-clarify and I will go to the basic of criminal law. Pwede po ba?
Yes, Your Honor.
If we will look at the structure of a crime, as you will note, there is no specific definition of terrorism. Tama po, Professor? Wala po tayong specific definition. In fact, countries have a different approach as well as how to deal with terrorism.
There is no accepted international
Yes,
consensus
yes.
on terrorism, but we do have a specific definition under Section 4.
Specific? No, I am referring to the definition that is being used by all the countries. There is no common definition.
There is none, Your Honor.
Yes, but there is a common structure of a crime. Structure of a crime which we refer to as the corpus delicti. Lahat po ng libro natin, speaking of a crime, corpus delicti consists of two elements. Tama po? Yun yung tinatawag nating actus reus and mens rea. Tama po?
Yes, Your Honor.
Wharton, a noted jurist, would consider the actus reus as the subjective element and the mens rea as the objective element. Tama po?
Yes, Your Honor.
So when these two elements are present, that would constitute a crime. Tama po?
As defined, yes, Your Honor.
Provided that there is a law penalizing that act. nullum crimen nulla pena sine lege under Article 21 of the revised Penal Code. Tama
Pursuant
po.
to the principle of legality, yes, Your Honor.
And this actus reus and mens rea came or rooted from the Latin maxim, actus non facit reum, nisi mens siti rea. Tama po. Or in other words,
I don't know Latin, Your Honor.
andyan po, hindi po.
Yes, Your Honor.
Hindi po Latin, actually po, we do not, a person do not commit a crime unless his mind is guilty.
Yes, Your Honor.
Yan.
I will take your word for it, Your Honor. I don't know Latin.
I know you know that. Ayaw mo lang aminin, Professor. Okay. So, the indispensable elements of a crime. One, actus reus, criminal act. Doing an act alone is not a criminal offense unless it is coupled with intent and below defining the crime and imposing a penalty.
Yes, Your Honor.
Okay. So that is precisely the structure of a crime. The actus reus consisting of the criminal acts are or maybe one act, two acts, or several acts. That is why when it is merely a single act, that may be a single crime. Isang act lang eh.
Yes, Your Honor.
And if there are several acts, complex in character, magkakaroon po tayo ng predicate crimes. Yan, napapasok ng predicate crimes. And these predicate crimes are still considered the actus reus. That predicate crimes solely may not be a crime unless it is coupled with the mens rea. Tama po.
Yes, Your Honor.
I will give a specific example for others to understand. Akala ko, Professor, alam niyo ito. Several predicate crimes, spatial complex crime, 267 to 94 of the revised Penal Code. Tama po.
Yes, Your Honor.
Spatial kidnapping with murder, robbery with homicide, etc. Alright, yan, may predicate crimes tayo. What is the crime committed? It depends upon the intent. So the intent will determine what is the nature of the crime. Even if there are predicate crimes, if they are guided by one single intent, those predicate crimes may be merged in the crime that is intended to be committed. For instance, robbery with homicide. If the intention or the nexus of the crime is the intent to gain, all other crimes included may be merged as one crime of robbery with homicide. Tama po?
Yes, Your Honor.
In the same way, as in money laundering, meron din tayong predicate crimes. Predicate crimes alone, without the intent to launder, wala tayong money laundering. In the same way as in plunder, 70-80.
Yes, Your Honor.
Malversation, bribery, solely, wala tayong plunder. Unless, papasok na yung intent. Tama po?
Yes, Your Honor.
The old anti-terrorism law, meron din tayong predicate crimes. And out of that predicate crimes plus the intent will make it a crime of human security violation. Otherwise, without the intent, hindi pwedeng violation ng Human Security Act.
Yes, Your
Tama
Honor.
po? In
Yes.
the same way, now ngayon, pupunta na po tayo ngayon sa ating batas na ating sinasabing unconstitutional. So, you will agree with me, Professor, that structurally, we have a perfect structured criminal offense.
Well, Your Honor,
Structurally,
the structure is
the-
standard, Your Honor.
yes,
Yes, Your Honor.
standard, because as I started with saying that there is no specific or definition, fixed standard definition, but there is a fixed standard insofar as the structure is concerned involving the corpus delicti. Dapat po doon tayo mag-start.
Yes, Your Honor.
Okay. So, since structurally it is a perfect crime structurally. Now, I will borrow the exhibit of Attorney Diokno. Wala lang kasi si Attorney Diokno eh. Exhibit ni Attorney Diokno. Yan. Yan po yung kanyang exhibit. Terrorism under Section 4, Republic Act 11479. Binanggit niya yung first essential element. And to me, that first essential element is the actus reus. And the second essential element, which is now the intent that will constitute the crime of terrorism, is the second element. So that actus reus alone or mens rea alone will not be considered as acts of terrorism. Tama po?
Yes, Your Honor.
Yes, sir. Ngayon, acts intended to cause death or serious bodily injury to any person or endangers a person's life. Very general, sabi ni Attorney Diokno. It is not specific. It does not even refer to the revised penal code. Tama po?
Yes, Your Honor.
Narinig nyo?
Yes, Your Honor.
Question, is the legislature precluded or prohibited from enacting a criminal offense which is generally worded?
No, it is not. But it cannot provide for crimes that are overbroad. Your Honor.
Generally
Which
worded.
it is in this case.
And it will be considered as a crime when there is a specific mens rea.
Yes, Your Honor.
Yes,
There's an
Your
intent, a
Honor.
criminal intent or a general intent.
Salamat. Nagkakaintindihan tayo, Professor. Now, there is no prohibition to generally worded provision of criminal law.
Well, Your Honor, I don't think it would be accurate, with due respect, to say there is no prohibition because overbread, no, Your Honor, overbread is a limitation.
Huwag muna tayo sa interpretation. Tignan na lang natin yan dahil yan naman po ang ating issue. Eh. Look at the first. I already read it. Acts intended to cause death or seriously bodily injury to any person or endangers a person's life. General in character.
I agree. It is general, Your Honor.
Correct. Do we need to specify those crimes that were mentioned?
Yes, Your Honor.
So, under the old law, acts that cause or intended death, iisa ang aking nakita doon. 9379, yung at 9379, yung old Human Security Act, 9372. Look, only single crime that involves bodily injury. What is that? Murder.
248, Your Honor.
Murder under 248. Question, Mr. Professor. Supposing it is homicide, supposing it is parricide, supposing it is infanticide, supposing it is plain and simple physical injury, it will not be included as a crime of terrorism because it is not murder, correct?
Yes, Your Honor.
You
But
will now limit
that was the intent, Your Honor, of Congress when they passed it.
You will now limit the discretion of the Congress to define what a crime is.
Well, may I answer your question regarding
Yes.
murder in the Human Security
Murder
Act?
lang nandun.
Yes, Your
nakita
Honor.
mo.
Yes, Your Honor. Again, under the Human Security Act, it only specifies murder.
Yes.
248 as a felony involving bodily injury. Your Honor.
Yes.
And yes, I do agree there are felonies against persons that are not included.
Yes.
Homicide, for example, parricide,
Yes.
infanticide. Your Honor.
Yes.
But again, Your Honor, in the same way that Congress is free to legislate generally, Congress specifically in its collective understanding, even wisdom, Your Honor, limited it to murder. Now, if, for example, Your Honor, they do decide at some later point in time that they may want to include, Your Honor, homicide, they may want to include other acts that would involve the taking of life, Your Honor, then they can amend, Your Honor.
Professor Tay, you are aware how fast technology is. You are aware of so many crimes that changes every day.
Yes, Your Honor, I do
Can we
agree.
legislate every day? To meet
Sorry, Your Honor.
can we legislate every day as fast as the development of a crime?
Well, Your Honor, in the same way, Your Honor, the general principle of legality of penal law does not allow us to legislate every day, Your Honor. There needs to
What
be
I'm
a
saying
law
here-
that prescribes the offense.
What I'm saying here, Professor, the legislature should be given the leeway, the discretion to anticipate crimes to be committed in the future.
Well,
Otherwise, we will be left behind. For instance, itong terrorism na lang. Nung una, wala naman tayong tinatawag na bioterrorism, walang tinatawag na cyber terrorism, walang financing terrorism. How can we meet the development of this different form of terrorism if we will not couch our penal laws in that kind of generality?
Well, with due respect, Your Honor, there are other special laws that deal with those. For example, Your Honor, the Cybercrime Protection Law makes every offense now and in the future committed through an ICT device a cybercrime. That has been challenged before this court in 2012 and the court in 2014 sustained some provisions and did not sustain other
The
provisions.
problem, Mr. Professor, is as we go on with our lives, one law, two laws, three laws, thousands of penal offenses already. And, you know, you were one of the members of the Code of Crimes. And we encountered the problem of including special laws with the revised penal code or the Code of Crimes. Why? Because there are more than 2,000 special laws. And we are finding difficulty how we can encode those 2,000 special laws.
Well, Your Honor, with due respect, I do agree that it's a practical problem. But
Yes,
again,
practical.
with due respect, that practical problem is, well, with due respect,
If that is the
not
case,
relevant to the question
if
of
that is the case,
constitutionality, Your Honor.
Professor, are we not infringing the wisdom of the legislature and their discretion to do that?
Well, Your Honor, yes, Congress can legislate general
Sige,
laws.
okay.
Again, there are accepted limitations.
All
Your Honor.
right, all right. Anyway, I have already established my point regarding the structure of a penal statute. As to whether this will be your interpretation, well, that is a different story.
Thank you, Your Honor.
Now, let us go to another point. Kanina, binanggit din ni Attorney Cadiz and Justice Alameda about these inchoate crimes, about preparatory crimes. And I have said a while ago, tendency crimes. Question, Mr. Professor, is it legally permissible to penalize those acts?
If they are penalized specifically as crimes, Your
Yes,
Honor,
of course, because of
then
nullum
yes.
crimen, nulla pena sine lege.
Again, under the principle of legality, Your Honor, as long as there is a law, and the law, Your Honor, does not
Even if it is-
not transgress, Your Honor, the Constitution, then yes.
Even if it is a mere preparatory act.
For so long, Your Honor, again, as it does not transgress the Constitution, and if I may expand, Your Honor, a law, a provision of law that penalizes a so-called inchoate, or
Yes.
may I use the word preparatory, Your Honor, rather
Yes,
than
okay,
inchoate, because inchoate is
preparatory.
misleading, Your Honor, because it may mean that it's not there yet. Preparatory, Your Honor, would refer specifically to overt acts that are visible, where the intention, the mens rea, as Your Honor points out, may then be inferred or clearly seen. Your
Is
Honor.
preparatory act a punishable act?
Your Honor,
Preparatory acts punishable?
not all, Your Honor.
Not all.
Article 8, for example, and of the revised penal code, conspiracy and proposal are punishable only
And
when they
Professor,
are expressly
You know what is the
provided, Your Honor.
reason why generally a preparatory act is not punishable? You know what is the reason why a preparatory
Yes, Your
act
Honor.
is not punishable?
Because it may not be clear, Your Honor, what the intent or what the
Yes,
resulting felony or crime.
because
People versus
a
Namahan, Your Honor.
preparatory act is an indeterminate act which may or may not ripen into an offense.
Yes, Your Honor.
Tama po.
Yes, Your Honor.
For instance, buying a poison to kill a person. That is a preparatory act.
Yes,
Correct?
Your Honor. Yes, Your
And
Honor.
it is not punishable because that crime of murder may or may not happen.
Well, murder may not be punishable. That may not be a preparatory
What
act to
I'm
murder, Your
saying
Honor.
is buying poison to kill a
To kill.
person.
Then yes, Your Honor, I agree.
Kasi murder yan eh, poison na
Yes, Your Honor,
ginamit
I
eh.
agree.
That is a preparatory act.
To murder, yes.
Wala pang overt act. Tama.
Yes, Your Honor.
Similarly, if one intends to commit rape and he sharpens his weapon, is that a preparatory act? Sharpening his weapon to commit rape?
With due respect, Your Honor, I don't know how to answer that question.
You cannot answer, Professor. 266-B. Rape with the use of a weapon is a qualified rape, punishable with death, reclusion perpetua to death. Hindi ba?
Well,
That is
Your
the
Honor,
weapon that I said it will be sharpened.
it is not an essential element to rape, Your Honor. It qualifies the offense of rape.
Yes. Preparatory.
So I cannot even say
qualified
it's
rape.
preparatory, Your Honor.
Okay.
It may be any other act.
Sige. Okay, Professor. Meron lang pa akong isang slide na ipapakita sa inyo. Ayan. That is the stages of a crime. Yun na yung kanina sinasabi nating preparatory acts and the acts of execution. Absent of acts of execution, as a rule, there is no crime because mere preparatory act is not a crime unless there is a law penalizing the same.
Yes, Your Honor.
Here, there is a specific law penalizing the preparatory act, correct? No, I'm using the structure.
Yes, Your Honor.
There is a law.
Yes, Your Honor. If by
Conspiracy.
preparatory acts we refer to proposal,
Yes, of
incitement,
course, of
conspiracy, planning, and threat, Your Honor.
Of
Yes.
course. That is, of course, what I mean. As a conspiracy is a preparatory act. You do not conspire solely without any purpose. You conspire for a certain purpose. But if that purpose is intended for terrorism, then conspiracy is committed. Tama po.
As stated in Section 7.
Yes, mere planning is not a crime unless it is coupled with intent to commit terrorism.
Again, Your Honor, as specified in Section 6. Yes.
Yes, correct. And indeterminate offense, as a rule, may be penalized if it is necessary for the state to do so.
An indeterminate offense,
Yes, indeterminate or preparatory acts. Pareho yan eh.
Well, with due
If
respect,
there is a necessity for the law to penalize, pwede.
with due respect, Your Honor, an indeterminate offense cannot be penalized, unlike a
I'm
preparatory act.
saying this is, if the legislature finds it necessary, there is no illegality, and it is permissible for the legislature to penalize a preparatory act when it is, quote and unquote, necessary.
Well, Your Honor, they can exercise their powers to legislate,
Yes.
but it does not, by that token, guarantee that it will survive constitutional review, Your Honor.
I am not talking of constitutional review. I am talking about necessity to justify the penal application of a preparatory act.
Well, I am not a member of Congress, Your Honor, but perhaps...
You did not be a member of Congress, Professor. This is criminal law.
Well, with due respect, Your Honor, because we're talking
Alright,
about the power
alright.
of Congress, Your Honor,
All right.
it would
I
have
will
to
go
be
to the
clear
point.
to Congress what are necessary.
I will go to the point which I want to specify. I said when it is necessary. This terrorism law, is it necessary for the legislature to enact and penalize, to enact a law and penalize a preparatory act?
Again, Your Honor, if we are to look at the policy statement in Section 2, Republic Act 11479.
Professor Tay,
That is where we get
that is yes, absolutely.
No, Your Honor, because it does not
Yes,
say so, Your Honor.
absolutely.
Well,
Why? Because compelling interest requires so. This is like rebellion. This is like treason. And worse, ang terrorism. That is why, at the nip of the bud, we should quell before it will happen. Therefore, even a mere tendency, a mere imminence of such crime, the legislature can already stop. So otherwise, we might be left behind. Remember that in this fight of terrorism, we should gain the upper hand. We should be one step ahead of the terrorists. We should not be behind. Otherwise, if we are behind, we better close shop against them. Tama.
Your Honor, may I be allowed to read a portion from Section 2, Your Honor, in answer to your question?
You don't need to read Section 2. I am just referring generally to a preparatory act that need to be penalized because of state necessity, it being a crime against national security.
Well, Your Honor, in order to respond to your question, I would need to
And
read,
there is
I
such
would
thing,
need
and
to
there
read
is such
Section 2,
thing
Your Honor.
in the international world or international, there is such thing as anticipatory self-defense, which is not applicable in Article 11 of the Revised Penal Code, applying self-defense.
Yes, Your Honor, I
And
agree with
crimes are enacted for several purposes, one of which is not only deterrence, but also the purposes for self-defense. Correct?
Well, not in relation to this law, Your Honor. Not in relation to this law, Your Honor. Again, may I be allowed to, Your Honor? Just in order to answer your question.
Just one. I am trying to understand your petition, but I am trying also to give you the point, the issue that we want to resolve. Because these are preparatory acts.
Yes, Your Honor.
And all of these are preparatory. We did not discuss the specific crimes, but there are crimes that are preparatory under the law.
Sorry, Your Honor, I didn't catch the
There
last part.
are preparatories that are being penalized under this.
Again, referring to conspiracy, proposal, threat, yes. Planning, yes, Your Honor.
Okay. So, ito kasi ang sinabi ni Dean Joke Nukapo nung nakaraan. Assembly, as long as it is peaceful, regardless of the intent, is not a crime. Tama po?
Yes, Your Honor.
If somebody is planning to commit terrorism, if there is a conspiracy to commit terrorism and they gathered in an assembly, would you consider that peaceful or not peaceful?
It would be peaceful, Your Honor, if they are just talking.
Okay, that is the actus reus.
Yes, Your Honor.
Couple it with the mens rea to commit terrorism. Will that not be a crime?
If you as defined, Your Honor, yes.
No.
As defined, Your Honor, we would have to follow the principle of legality, Your Honor, with due respect.
That's why
So
I
as defined, yes.
I mentioned actus reus and mens rea.
Yes, as defined, yes.
Assembly is the actus reus, mens rea, plus, in addition, will make it a crime.
Yes, Your Honor.
Therefore, an assembly, even if it is peaceful, if the intent is against the law, is considered a crime.
Yes, Your
Yes, sir.
Honor. Yes, Your Honor.
Salamat po,
Thank you, Your Honor.
Mr. Professor Tay.
Thank you, Your Honor.
Magaling po kayo. I have just a few, Chief, isa lang, konting tanong lang para kay Professor Molo.
Okay, sige, go ahead.
Don't worry, Professor Molo.
Good afternoon, Justice.
I will not be as exhaustive and disquisitive as your professor, Justice Lonen. Wala rito eh. I will not
Sanay na
be-
po, Your Honor.
Sanay ka na. Anyway, as I have said, I will be very careful with you. Knowing that you are an expert of constitutional law.
Hindi naman po, Your Honor. Nag-aaral lang.
Although tinanong ka ni Justice Kagiwa about attempted felony.
Ay, wala na po akong alam sa criminal law. The real experts are behind me.
Yeah, no, but this is not purely criminal law.
Apo.
Criminal law in relation to void and vagueness rule. Okay?
Opo.
Pakikuan mo yung isang slide dyan, iya. Ayan. Ayan lang naman ang aking tatanong sa iyo eh.
Opo.
Void for vagueness or over breadth. It involves facial challenge or as applied. Tama po.
Opo.
When we say facial challenge, it is a contextual challenge. There is no specific person involved.
Opo.
Whereas, as applied, there is now a person involved and there is a prejudice that is forthcoming.
Ay, mali po. Ang facial challenge may person
As
involved and there's a
applied.
prejudice.
As applied ang sinasabi ko.
Hindi yun po. Facial challenge involves a person who is actually also
As
being
applied
burdened.
ang sinasabi ko, Prof.
Ay, kaya nga po, under constitutional law, facial challenge also involves a case or controversy where a person's rights are burdened. It is a misnomer to say that there's no case or controversy in a facial challenge. That's different from criminal law.
Ano yung as applied?
As applied, Your Honor, is someone who has actually suffered criminal
That is what I am
prosecution
saying.
under the law.
There is
Different po
already-
yun.
there
Pending
is
case is not
already-
actual
yes,
case.
There is already a person who is
Criminally charged, Your Honor.
yes, that is what I am saying.
Yes, Your Honor.
That is my understanding of vague for vagueness rule.
Yes, Your Honor. Tama po
applied
kayo.
to criminal law.
Yes, Your
Kaya nga
Honor.
criminal law nandyan mo.
Opo, kasi nga ang facial challenge, halimbawa po,
Yes.
yung mga madre under support, their rights to believe are already burdened. Kasi kung madre ka under the ATA, magbigay ka lang ng alms.
Sandali, wala ta-
Kulong ka na
wala-
for
wala-
life imprisonment.
Prof,
That's a
sandali,
religious
sandali,
burden.
Sandali, Prof.
Yes, yes, Your Honor.
Wala akong issue dyan.
Yes, Your Honor.
Ang sinasabi ko lang yung as applied in terms of criminal law.
Yes, Your Honor.
Eh, yung sinasabi mo mga madre, walang kinalaman ng criminal law doon.
Sige po, Your Honor.
So, our jurisprudence is this void for vagueness rule does not apply to criminal law.
Not true, Your Honor.
Not true.
Not true. And I'm quoting Vicente V. Mendoza, one of our esteemed constitutionalists, Your Honor.
Mm.
That's not true. There's the in-terrorem effect. I believe that is what you are referring to, Your Honor.
Yes, yes, yes.
That does
yes,
not apply
correct.
to a
Yun
facial
ang sabi
challenge.
ni Bibi Mendoza eh.
Hindi po. Kausap ko po si Vivi Mendoza several times, lalo na po sa
Okay.
Constitutional Law Cluster. Hindi daw po yun ang ibig sabihin niya at sinulat niya po yan sa mga desisyon niya.
We go specifically. Estrada, ano sinabi na Estrada about void for vagueness rule?
That is the general rule with as applied
Okay,
challenges.
general
If
rule.
it doesn't involve a fundamental right or a penal law that
Okay,
affects free speech.
alright.
General rule. This
In-apply ba yung
ATA is
general
the
rule?
exception.
In-apply
Isini.
ba yung general rule? Sa Estrada?
Yes, Your Honor. Plunder
Yes,
yun
Your
eh.
Honor. Okay, plunder. But
That's not a speech act.
it is not facial challenge.
It was a facial challenge by
because
Pacifico
Estrada-
Agabin, our former dean, Your Honor.
Professor, sandali. Pakinggan mo muna ako.
Yes, Your Honor. Sorry.
Inuunahan mo ang husgado.
Sorry, Your Honor. Sorry, Your Honor.
Kaya ako as applied, sinabi ko sa Estrada, dahil nandyan na si Estrada. Kung wala si Estrada, would you think that will be applied?
Your Honor, in Estrada versus Desierto, it was actually a facial challenge filed by Pacifico Agabin. But the Honorable Court treated it as an as-applied. Because there was somebody charged.
Exactly. Yan ang sinasabi ko. Andyan na si Estrada.
Yes po.
Kung wala si Estrada, would you say the same ruling will be applied?
Oh, differently po.
Oh, yan na. That's what I'm saying. Inuunahan
Yes, Your
mo
Honor.
kasi ako eh. In the same way as the other cases, as applied ang ginamit.
Aling other cases po, Your Honor? Disini, facial po yun. Nicholas Lewis is facial.
Alright. Alright. I agree. It is only in that crime of Disini where a facial challenge without any specific person involved, that void for vagueness rule was applied.
Unfortunately, Your Honor, I have to disagree kasi may Imbong versus Ochoa ka pa. May
Is
Ople
that
versus
a
Torres ka
criminal
pa.
offense?
Yes, Your Honor.
What
Imbong
is the
versus
criminal
Ochoa,
offense?
RH law.
RH law.
Yes, Your Honor. Because the doctors, the religious belief, they will go to jail if they don't prescribe an abortifacient.
It is a criminal offense. I will agree on that point. Madali naman akong kausap eh.
Salamat po, Your Honor.
And what is the reason why void for vagueness rule was applied?
In which case po sa
Yung
Imbong?
sinasabi mong
Yes, Your
Imbong.
Honor. Because precisely of the vagueness, Your Honor, it chills. Actually, the phrase of the Honorable Court
Right
actually
of
says
expression
it
or
chills.
freedom of expression is involved. Kasi
Yes,
pwede
Your
lang
Honor.
naman sabihin,
Yes, Your
pinapahaba mo pa eh.
Yes, Your Honor.
Same way in the cine, freedom of expression
Yes,
is
Your
involved.
Honor.
In
And
other
other
words,
fundamental rights.
in all of these cases, void for vagueness rule involves that protected right of expression.
Yes, Your Honor, I agree.
You agree. Can you tell me the nature of the crimes involved in those instances where void for vagueness rule was applied?
Nature?
Yes, nature of the crime.
I'm not sure what the
You are
question
not
asks for,
sure.
Your Honor.
I will refresh your criminal law.
Yes, Your Honor.
There are 14 titles in the revised penal code, correct?
Mas magaling po kayo sa akin sa criminal law. Wala po ako, hindi ko po maalam.
First year yan eh.
Tama po kayo. I will,
14 titles.
opo.
Crimes against property, alam mo yan. Crimes against persons, Title 8. Title 10, property. 11, your favorite one, crimes against chastity. Hindi ba?
Not my favorite, Your Honor.
Title 4, biro lang. Title 4, joke. Title 4, public interest. Title 2, ayan siguro favorite mo.
Crimes against public order?
No.
Ah,
Crimes against the fundamental laws of the land. Andyan yung 124, 125, 126, arbitrary detention. Nandyan yung offending religious feelings. Nandyan yung search, unreasonable search, domicile, etc., etc.
Opo.
Ayan. Now, refresh with that kinds of crimes. Would you tell the court what are the nature of the crimes in those cases where void for vagueness rule was applied? Isa-isahin natin. Just tell me and I will tell you what is the nature of the crime where void for vagueness rule was applied.
crimes against
Yes.
the fundamental laws of the
Just
state.
tell me the case.
Imbong.
Imbong, what is the crime involved?
Your Honor, failure to prescribe an abortifacient.
What is the nature of the crime?
It's a special law, Your Honor, so I don't know where in the RPC it falls under.
It's not, it's a special law.
RH law kasi yun, Your Honor. Eh.
Kaya nga, but if it involves falsification, public interest yan.
Ganun po ba? Sige, Your Honor.
Yes. But if involves abortion, Title 8 yan.
Yes, Your Honor.
against person. Tama?
Yes, Your Honor.
Alright, Imbong. Next.
Dicini, Your Honor.
Dicini.
The Cybercrime Act.
Alright. What is the nature of the crime of cybercrime law?
The nature of the crime of cybercrime
Yes.
also. Crime against public order.
Public order, pwede. But specifically, it involves a crime against public interest. Bakit public interest?
I believe it is against the public interest for these cyber attacks to happen, Your Honor.
Social media is involved. It involves the interest of the public.
Opo.
Social media, hindi ba?
Opo.
Alright. And you are saying that Ochoa and that of Dicini, both cases are applicable to Anti-Terrorism Act.
Opo.
Yes, sir. Void for vagueness rule.
Opo.
Because it also involved freedom of expression.
And fundamental rights. Yes, Your Honor.
Yes, freedom of expression na sinabi ko na eh. Okay. Now, next question. What is the nature of the crime involved in terrorism law?
Based on your questioning, Your Honor, maybe public order as well.
Public order and terrorism?
Interest. A crime against public order and
Public
a crime
order
against
and
public interest.
terrorism?
I believe so, Your Honor.
Crimes, kanina pa natin pinag-uusapan, national security.
Opo. Opo.
Hindi ba?
Opo. Opo.
In our jurisprudence, never did we use that void for vagueness use in crimes involving national security.
I will have to
In
check, Your Honor.
fact, Southern Hemisphere said that is not applicable.
Well, Your Honor, Southern Hemisphere is not a free speech case, Your Honor, because that's what Justice Carpio Morales, my client, said in her ponencia. It was not treated as a fundamental rights case, Your Honor.
Same as the terrorism law, which is classified as a crime against national interest.
Well, Your Honor, I would really beg to disagree that if we're gonna carve out... Yes, Your
I
Honor.
will give you a chance to talk. Don't
Sige
worry.
po.
Pakinggan mo lang ako.
Opo. Sorry.
Because I have surveyed all these cases, never in our jurisprudence where this void for vagueness rule was applied in a facial challenge, particularly if we're talking of facial challenge, void for vagueness rule was applied in crimes involving national security.
Terrorism po. Opo.
Yes. Yun ang ating pinag-uusapan.
Honor.
Never.
Yes, Your Honor.
When the
And
crime
may
involves
I
national-
respond?
Teka muna.
Sige po.
At tapusin mo lang ako at hindi tayo magkakaintindihan if you will go on with me.
Okay po.
Tapusin mo lang ako. I will give you a chance. Since this involves a crime against national security, it is more than the fundamental rights. Why? Because what is affected in crimes against national security is not only the people's right, correct? In national security of the state, what is involved? The right of the people, the state's right to its sovereignty, to its government, and that of its territory. Tama?
Tama po kayo.
Okay. That is why, because of this broadness and danger that lurks behind the enactment of the law, void for vagueness rule was never applied even in some other countries. In other words, here speaking of crimes against national security, the main issue is not the presence of that right, freedom of expression, but rather the compelling state interest to justify that freedom of expression that you are now invoking before this court. If I may show you this slide. Last slide. In other words, the focus of the anti-terrorism law should be national, state, and security. As such, the real issue is whether the state has compelling interest to restrict the individual's fundamental right.
May I respond, Your Honor?
Huwag lang matagal. Dahil
Maiksi
yan
lang
ang-
po.
Sige.
May nakalimutan po. May second element sa compelling state interest, narrow tailoring. Pag may compelling state interest ka, the means have to be narrowly tailored. If we do not allow facial challenges, even if inuubos na ang mga tao, isagad na po natin national security.
Inunahan mo na naman ako kasi.
I thought you wanted me to answer.
Ayun na,
I will
ito
back
na
out.
test. You're not telling me the test.
Yes, Your Honor.
Compelling state interest versus right of the people, fundamental right. Ayan ang test. And what are the test? Do we use? Yun ang sasabihin ko ngayon. Inunahan mo kasi
Yun
na
lang
naman
po.
ako
Opo.
eh. Di ba? Rational, rational test or reasonable test, tama? Intermediate test, strict scrutiny test. These are being applied. Correct?
Strict scrutiny pag fundamental right, Your Honor.
Yes, ayan na nga sinasabi ko eh, strict scrutiny.
Opo.
But since, as I have shown there, it is the national state security which is involved, there may be a higher level of scrutiny more than the strict scrutiny test.
Ang tinitest po ng strict scrutiny yung state,
Yes,
hindi po yung
existence,
right to free
right of
speech.
the
Baliktad
state.
po.
Right of the state versus the fundamental. Binaliktad ko specifically because what is involved here is the state, its interest and security, and not the fundamental law of the land.
Well,
Yan ang
I would
gusto
have
kong
to
sabihin.
beg,
Alright.
very respectfully beg to disagree, Your
Alright.
Honor.
That is
The
why-
burden is on the state if it chose unconstitutional
Okay.
means, strict scrutiny of the
Professor,
means, not of the person's right.
Professor, dakdak ka na naman ng dakdak mamaya. In-anticipate mo lahat ng sinasabi ko eh.
Oh, sige.
If you disagree, I will give you a chance. Don't
Opo.
worry. And this is your chance. After I have said everything, this is your chance. Next. File your memorandum to that effect after the Solicitor General has said its piece. Hindi tayo matatapos if I will let you talk and talk. Tama?
Yes, Your
All
Honor.
right. Thank you, Professor.
Yes, Your Honor. Thank you very much, Your Honor. And my apologies, Your Honor.
Yun ang gusto ko lang sabihin, yung point ng husgado.
Salamat po, Your Honor.
Iniintindi namin kayo. Eh, yun
Salamat
ang
po.
pagkaintindi na namin, ibigay nyo sa amin kung ano yung pagkaintindi nyo sa batas. And we cannot take those things here in the oral argument because we have a limited time.
Opo, we will include it in our memorandum, Your Honor.
Kasi baka naman sasagutin ka na ng
Ay,
surgeon
opo.
eh.
Opo.
Di ba?
Opo.
Kung hindi kasi that will be, and maybe I will also include that, if ever, that issue will come out in the course of the resolution of the court of your petition.
Salamat po, Your Honor.
Salamat din,
Pasensya na
Professor.
po, Your Honor.
Chief, I'm done.
Who is next? Justice De Los Santos? Yes? Okay, go ahead. Go ahead.
Thank you, Chief. May I call on Congressman Colmenares?
Thank you po, Your Honor.
Good afternoon, Congressman. Is it true that you're from Iloilo? Are you
Yes,
from-
well, Your Honor, Western Visayas po, Negros, Iloilo, ug Cebu, Your Honor. More or
I
less.
see. Mayong hapon. Mayong aga. Mayong aga, Congressman.
Mayng hapon ho, mayng hapon man, mga Ilonggo.
Well, I prepared about 50 questions.
50 po.
But due to time constraint, and you must have heard my esteemed colleague, Justice Mario Lopez, we have limited time. I'll be asking only about 3 to 5 questions.
Opo, opo. I'll try to answer po.
Now, in your petitions, Congressman, You claim that the passage of the Anti-Terrorism Act has its chilling effect on the rights of the petitioners, right?
Correct po, yes.
Or that the Anti-Terrorism Act's chilling effect is palpable.
Opo.
Do you mean to say that you fear the passage of the law?
Yes po, the chilling effect is actually a presumption of law, and it is actually, Your Honor, the fact that one second guess whether or not the law covers your acts. That's the general principle of the law, Your Honor. However, in actual also, other than the general principle of the law, yes, the fact that I exercise my rights sometimes does not mean I'm not chilled. Chilling, Your Honor, is chilled. It's not frozen. It doesn't mean silence. So, yes, Your Honor, I say that we are chilled, Your Honor.
So we know whether the passage of the Anti-Terrorism Act has its chilling effect
Yes, Your
only on
Honor.
the rights of the petitioners. What
Yes.
about the people from Manila and nearby cities?
Yes, Your Honor. We contend that third parties, the chilling effect also could involve the third parties, Your Honor.
Can chilling effect be quantified?
Probably, Your Honor, but I can give examples. For example, we have online forums where I invite people to be speakers and they say, no, baka ma-anti-terror law tayo eh. So they already have this fear of exercising their constitutional right because they believe that my surveillance, my freezing, a mere suspect can be arrested. So that really chills them, Your Honor.
Is it by the number of abuses of the law enforcers, or is it the number of victims of terroristic attacks?
No, Your Honor. Chilling effect is a presumption of law, Your Honor. It's not an issue of how many are chilled and how many are not chilled. But if the law is overbroad, Your Honor, that any act can be that the act can encompass the legitimate exercise of constitutional rights, and people refrain or self-censor in their exercise of these rights, then that is the chilling effect, Your
All
Honor.
right. During last week's oral arguments, my esteemed colleague, Justice Amy Lazaro Javier, revealed a definite figure as to the total number of bombings that occurred in Mindanao. This was during her interpellation of your colleague, Attorney Molo, Professor Molo. She said that from 1971 to the present, there's a total of 78 bombings reported in Mindanao, with hundreds, if not thousands, of victims, including children, pregnant women, elderly, or old people who are either maimed beyond recognition and died, or decapitated, dismembered, or severely injured. I think you will agree with me that this gruesome picture of violence and death has a chilling effect on the survivors and the witnesses of the senseless bombings, right?
Well, they're actually injured, Your Honor. So in that sense, yes. But the question before this court is whether or not the anti-terror law is constitutional. Otherwise, Your Honor, if it's always an issue of the effect, then the government can always argue the heinousness of the crime, even if it's unconstitutional, on the mere basis that, it has a heinous effect. That will actually make all these oral arguments useless in the sense, because it kills people, it's bombing, it's heinous, then there's nothing to talk about, Your Honor. But because the court is tasked whether or not the law grants unbridled discretion for them to implement, whether they will implement it or not is not an issue here, but the fact that they have the discretion to choose it against a terrorist and against a dissenter, that is an issue here, Your Honor. So the fact we agree, Your Honor, terrorism is bad, it's a heinous crime, but we say to them during the congressional hearings, there is HSA. They always mention the bombing of Hulu, the Marawi. I asked, what part of HSA made you fail in stopping Marawi? They cannot cite any, Your Honor, because it was not the HSA that was the problem. And as the former Solicitor General said, it's actually the implementation of the intelligence work. If your intelligence work, Your Honor, says that Alex Padilla and Juan de Barrios are CPP and PA, then nothing will come out of this. Kahit 10 anti-terror law ang ipasa natin, Your Honor, pag ganun ang intelligence work nila, walang pangyayari dito, Your Honor. So they cited Marawi. We say, can you put that in the law? They don't want to put bombing in the law. They don't want the predicate crime. They just want any act, any act. That's the problem, Your Honor.
Okay,
Any
okay.
act could be legal or illegal.
Thank you,
Your
Congressman.
Honor. Thank you po.
As again pointed out by Justice Javier, aren't we supposed to balance the interest of the vigilant guardians of democracy and the greater number of peace-loving Filipinos? Sounds utopian.
Sorry, Your Honor. The question was?
It's are we not supposed to balance the interest of the vigilant guardians of democracy and the greater number of peace-loving Filipinos?
Well, according to the jurisprudence of this court, the strict scrutiny rule applies here. And it is up, this law is not presumed constitutional under your strict scrutiny rule. This law is presumed unconstitutional, and it is up for the government to prove compelling state interest, and that this compelling state interest is not achieved by a narrowly tailored law, Your Honor. That's the jurisprudence of this court. So the balancing of interest, maybe in a policy decision, maybe they will say the executive can balance, but this court, Your Honor, is precluded from doing that, I think, Your Honor, because precisely the issue here is constitutional po, Your Honor.
Just to paraphrase what our amicus curiae said, Justice Francis Arilesa, we should be guided not by fear or speculation, but by actual facts. In fact, in one case,
this court said, the sea of suspicion has no shore. It is just like a boat without a rudder. Literally in Tagalog, it means, ang dagat daw ng paghihinala ay walang dalampasigan. Ang paghihinala ay maihantulad sa isang sasakyang dagat na walang ilisi, or rather, ikot ng ikot, walang malinaw na patutunguhan. Let us therefore avoid substituting facts with fears, suspicions, and paranoia. Now, question, in your opinion, is it proper for the people to surrender their privacy rights to a reasonable extent in order to prevent the loss of lives? And what is reasonable extent in your understanding? To borrow the language of another senior member of this court, I'm referring to Justice Kagiwa. Please educate me, Congressman.
Salamat po. Una muna po, yung rights ng mamamayan, of course, sinabi na kanina na hindi naman absolute yan. The court has said so many times, pwede namang ma-restrict yan. Basta, in strict scrutiny rule, ito ba the narrowly tailored, the least restrictive? Secondly, ang sabi namin, draconian ang Human Security Act. Pero pag ma-strike down ng ATL, Your Honor, we are not defenseless. The Human Security Act is a draconian and repressive measure that can actually give government the tool. Any suspect, Your Honor, can be arrested under the Human Security Act. They can monitor, they can freeze, they can surveillance, they can listen to your communication, everything, Your Honor. Except that they have a penalty of 500,000 per day, which, if you notice, Your Honor, all the bills in Congress were for the amendment of the Human Security Act, even the Senate. And we were so surprised when the Senate version came, it was the complete repeal of the Human Security Act, when in fact, they themselves, when I asked them, what part of the Human Security Act was the weakness? They couldn't mention any except the 500,000 pesos. Did a terrorist escape because of the weakness of the Human Security Act? They could not pinpoint a specific provision, Your Honor. So when they paint a picture that, oh, if we don't have the terror law, we will be defenseless, the terrorists will run rampage here, is not true, Your Honor.
Okay,
the revised Penal Code and the Human Security Act are more than equipped to deal with this, Your Honor, please.
What is your idea of the social contract theory? You must have encountered this in your pre-law years.
Yeah, I heard that during my freshman year.
Yeah, this was espoused and made famous by ancient political philosophers like John Locke and Thomas Hobbes.
Yes, Your Honor. That the government is put up by the people with the contract that the government shall ensure the welfare of the nation, but the people put restrictions, of course, on the power of government.
Yes, the Philippine Constitution is an example of a social contract. It sets out what the government can and cannot do. Its essence is that the will of the people as a whole gives power and direction to the state. Please allow me to read what this court said in the case of Marcos versus Manglapos. The Constitution, aside from being an allocation of power, is also a social contract, whereby the people have surrendered their sovereign powers to the state for the common good. Now, with respect to the implementation of laws, social contract theory is important to justify the power that law enforcement can exert over the population as a whole. This power held by law enforcement is part of the contract that society has agreed upon in exchange for security. Now, with respect to the implementation of laws, including the Anti-Terrorism Act, I have two interrelated questions. Please allow me to finish first my two questions before you'll answer. First question, can the constitutionality of a law passed by Congress be made dependent on the acts of the executive department during implementation? For example, the law enforcers. Second, may this court adjudge a law or ordinance as unconstitutional on the ground that its implementer committed illegal acts?
Can I answer that? Thank you, Your Honor. In the first place, the social contract theory or any other power exercised by government is not absolute, Your Honor. It is restrained by the Constitution, and this honorable court has said so several times. And the first question, Your Honor, was...
Yes. Can the constitutionality of a law passed by Congress be made dependent on the acts of the executive department during implementation? In other words,
Yes,
if
Your Honor.
there are abuses, there have been
Yes.
abuses committed by the implementers, would it justify the declaration of the law as unconstitutional?
Thank you, Your Honor. Actually, the issue before this is not whether or not they will abuse. The issue before this court is whether they are given the unbridled discretion to enforce the law. Now, will they violate my right? Maybe yes, maybe no. But the question before this court is, are they given the discretion to choose who will be the suspect, who will be arrested, who will not be arrested? That is the problem. So whether or not they will abuse this, Your Honor, is of no primary moment, Your Honor. The fact is, are they given the unbridled discretion? And the court has declared so many times laws as unconstitutional because of unbridled discretion, not on whether they abused it or not abused it, but on the fact that they can abuse it with unbridled discretion. That's why the cybercrime law was actually struck down. They have not yet implemented it against us petitioners, but the law said, no, you were given all the discretion. It's unbridled. There's no limit. There's no restraint. And the court struck down certain provisions of the cybercrime law, Your Honor.
Congressman, are you saying that the Anti-Terrorism Act should be nullified due to the unbridled discretion given to the law enforcers in the implementation of the laws? That the law is prone to abuses on the part of the law enforcers?
Yeah, well, Your Honor, unbridled discretion is there. For example, any suspect can be arrested for 10 days, even if you're not designated, even if you're not proscribed. If you're a suspect, that's what the law says. Can they choose who to arrest? Yes, of course. EDSA, I go back to EDSA. Was EDSA a terrorist act under Section 4? Yes, Your Honor. It was an act intended to seriously interfere with critical infrastructure. And the intention of EDSA, People Power 1, was to paralyze the traffic in Metro Manila, Your Honor, for Marcos. Was it for the intimidation by provocation the government? Yes, Your Honor. The intention was Marcos step down. So that falls in Section 4. The fact that Section 4 allows for EDSA to be considered a terrorist act makes it unbridled. They may use it against the Maute, but the court has said, no, they can choose EDSA other than Maute. And just, Your Honor, please, do they really need a law for the Maute or for the Abu Sayyaf? Your Honor, drug suspect ka sa Pilipinas, patay ka, Your Honor. How much more if you're a terrorist suspect, Your Honor? That's why we always said, define the law. Ano ba yan? Bombing, killing, ayaw nila, any act lang ang gusto nila. They overreached, Your Honor. They overreached. That's why it's questioned now, because they reached for people like us. I couldn't imagine the army thinking, i-raid na lang yung Abu Sayyaf o ambushin na lang ang Abu Sayyaf. They would say, walang terror law, hindi pwede. No, Your Honor. That is why they are not defenseless, even if this court invalidates the ATL. The Human Security Act is there, Your Honor, the revised penal code, and many special laws, Your Honor, can contend with the Terrorist Act
Thank you,
mentioned, Your
Congressman.
Honor. Salamat po.
Now, with due respect, let us apply your contention in the context of other penal laws to demonstrate the effects of allowing the nullification of a statute based on the acts of the implementers. We in the court have been resolving cases involving illegal possession of drugs under Republic Act number 9165. Do you suggest that we also declare Section 11 of Republic Act number 9165 as unconstitutional simply because the police officers have been planting evidence in violation of Section 21 of the same law?
No, Your Honor. The act is very well defined, and the act is not unbridled, Your Honor. Any law can be abused. As long as it does not give unbridled discretion, it is not questionable constitutionally. What is being in issue, Your Honor, is not the fact that they will abuse it, Your Honor, because, it's facial challenge, but the fact that it gives them the discretion, unbridled discretion to implement it. And the law has to strike down a law, Your Honor, that gives them unbridled discretion. As I've said, they're not hopeless, Your Honor, under current situation, as if they're portraying themselves that if the anti-terror law is gone, we have no other way to stop the terrorists. They have, Your Honor. It's just that we're questioning the unbridled discretion given to them, Your Honor.
Thank you, Congressman.
Salamat.
Please allow me to read what this court had said in the case of David versus Arroyo. This court declared, settled is the rule that courts are not at liberty to declare statutes invalid, although they may be abused and misused, and may afford an opportunity for abuses in the manner of application. The validity of a statute or ordinance is to be determined from its general purpose and its efficiency to accomplish the end desired, not from the effects in a particular case, for example, abuse in its implementation or enforcement. Now, I have one last question for you.
Opo.
Can Congress be expected to predict all possible abuses that law enforcers may commit during the implementation of the statute?
No, Your Honor. And in fact, I agree with you in Arroyo about the statement that a law cannot be invalidated on the mere possibility that it will be abused. That is why I was saying kanina, Your Honor, that it's not an issue kung maabuso siya o hindi. I'm not even claiming that. I mean, I can always argue that I've been, a victim of that. But the fact is, the unbridled discretion, Your Honor, that gives them the power. Imagine all the safeguards, Your Honor. Actually, there are safeguards there in that sense, but they're illusory, Your Honor. What are the safeguards there? When the law has practically allowed everything legal. If they arrest you for for 24 days, you go on habeas corpus or writ of amparo. What is the rule on writ of amparo? An unlawful act or omission of the enforcer. But they will say, look, it was lawful. Section 29 says so. So what is the illusion of the safeguards they enumerated? Actually is not there. They have the unbridled discretion to already do what is legal, what is unconstitutional in a legal manner, Your Honor, foreclosing any remedy po.
Are you trying to say, Congressman, that there are not enough safeguards in the Anti-Terrorism Act?
I don't think there will be a safeguard with Section 4, Your Honor. It will be an unbridled discretion.
Right.
No way, Your Honor.
Final question. Would you agree with me, Congressman, that all laws, including a mere municipal ordinance penalizing violations of anti-jaywalking, may be abused by their implementers or by the law enforcers?
It's possible, Your Honor, but that's not an issue here, Your Honor.
Okay. Damo gid salamat, Congressman.
Madamo gid nga salamat, Justice. Thank you, gid. Salamat.
May I call on Professor Atty. Molo? I have only 2 questions. Good afternoon, Atty. Molo. Professor, in the case of Arroyo versus Aquino III, this court said, Congress acts with imperfect knowledge in trying to legislate in fields that are highly technical and constantly undergoing change. And intelligent legislation on the complicated problems of modern society is impossible in the absence of accurate information on the part of the legislators and any reasonable method of securing such information is proper. This is the case of Alcantara versus Ermita. Now, technology has progressed at a rapid pace. The same is utilized by government and lawless elements alike. Are you in favor of giving government authorities the access to technological capabilities in the same manner as prospective terrorists can?
No. Yes, Your Honor. Whatever weapon is
Your answer
available
is yes,
to...
not no.
Yes, Your Honor.
Yes.
Yes, Your Honor. Whatever weapon is available to terrorists should also be available to law enforcers.
So you are willing to allow an intrusion of privacy to a certain extent, as long as there is a probable cause and there is prior issuance of a judicial warrant?
Your Honor, as I confessed earlier, I am the son of a soldier. My answer is yes.
You made mention that your father was a soldier, assigned what?
Assigned, Your Honor, first to Mindanao, then to Leyte, then to Samar, Your Honor.
You're from Mindanao?
We are from Bicol, Your Honor, where
Bicol.
my lolo naman was a police chief. So I am in favor, Your Honor, of law and order, actually. Unlike other people behind me, Your Honor, I am pro national security, actually, Your Honor. But it's just that the law is too overbroad.
Okay. Well, last question.
Yes, Your Honor.
Professor. When you were interpellated by Justice Kagiwa, you mentioned that the CPP, NPA, and NDF are not classified as terrorist groups or organizations. Can you recall what this court said in the case of Southern Hemisphere with respect to the status of these organizations?
I believe, Your Honor, they were designated recently by the Anti-Terrorism Council, Your Honor, the CCPP NPA, Your Honor.
Okay. In the separate opinion written by yours truly in the case of Almonte versus People, and quoting the case of Southern Hemisphere, this court said, the state's measure of continually detaining the petitioners is reasonably related to its objective of maintaining public order and preserving public safety. While there is still no judicially declared terrorist organization in our jurisdiction, pursuant to Section 17 of Republic Act Number 9372 or the Human Security Act of 2007 to date, the United States and the European Union have both classified the CPP, NPA, and Abu Sayyaf Group as foreign terrorist organizations. Any comment to this declaration by this court?
I completely agree, Your Honor, with the classification of them being terrorist organizations. The Abu Sayyaf? Yes, Your Honor.
Okay, thank you very much, Professor. Chief, I'm done. Thank you.
Okay. Justice Garland? Okay.
Yes, just
Go
a
ahead.
few questions, Chief, and it will not take me that long. I need only about 3 minutes. May I call on Attorney Theodore Te? Good afternoon, Attorney Te. You've been a part of this Supreme Court family.
Good afternoon, Justice.
As a spokesman during the watch of then Chief Justice Lourdes Sereno, so I'm sure you have a full grasp of how the court thinks. So may I just ask you some or a few questions? Okay.
With pleasure, Your Honor.
Let's go to the issue again of separation of powers, being a part then of the judiciary. Would you agree that when courts supplant their own wisdom to a legislative act under the guise of judicial review, the same is tantamount to judicial legislation?
Your Honor, the parameters that the Constitution have set for the courts to exercise its power under Article 8, particularly Section 1, are clear, Your Honor. So when we do say that the court acts pursuant to its powers, it is not a case of the court supplanting its judgment or wisdom. I would recall Angara versus Electoral Commission, Your Honor, where this court interpreted it as not a supremacy of the court, but a supremacy of the Constitution, Your Honor. So the constitutional architecture allows this court to act in a particular way. For so long as the court acts within the powers, the parameters that the Constitution defines, then it is not a question of supplanting, or it's not a question of judicial legislation, Your Honor.
But do you think that judicial review, if abuse, would erode the people's confidence in the delicate system of checks and balances and tip the scales to one side in derogation of the separation of powers?
And well, Your Honor, unfortunately, because this is the Supreme Court we are talking about, I am at a loss as to how someone can accuse the court of abuse, Your Honor, because you are the final, this court is the final resort. If the court makes a pronouncement, Your Honor, on what the Constitution means or what the law means, that is what the law means, that is what the Constitution means. And everyone is bound by that. We may disagree, we may agree, we may disagree with the court's opinion, but that is the court's opinion, and that now becomes the interpretation of the Constitution or the law in relation to the facts presented, Your Honor.
So given the framework and wording of the Constitution and its contemporary interpretation, do you think it allows for the judiciary to take an active role in public policy formulation? If so, do you think the exercise of judicial review in this context violates the doctrine of separation of power?
I do not believe it does, Your Honor. I would call to mind Article 8, Section 1, particularly Paragraph 2. The last portion of Paragraph 2 does give the court the expanded jurisdiction to inquire and act upon grave abuse of discretion by any branch, instrumentality, or agency of the government. And by branch, Your Honor, we would refer to the two other branches of government, the executive branch and Congress, Your Honor.
Okay. Yes, the expanded definition of judicial review in the 1987 Constitution explicitly contemplates constitutional judicial review.
Yes, Your Honor.
In your opinion, does the 1987 Constitution allow a priori or an ex post facto review of legislation?
I'm not sure, Your Honor, what we mean by ex post facto, after the fact. Well, every review, Your Honor, comes to the court after the fact, after the Congress passes a law. But I would suppose, Your Honor, if we were to say a priori, meaning before someone is charged, then yes, Your Honor, this court has allowed, Your Honor, challenges like those. And I think that is what we would call facial challenges, Your Honor, to the law itself.
American common law, which our tradition adopted, favors ex post facto constitutional review, while continental Europe or the civil law tradition, which has likewise found its way through our civil and penal law, favors a priori constitutional judicial review. Would you agree that the creation by this body of exceptions to requirements that an actual controversy is present, such as transcendental importance and matters capable of repetition but evading review, have made the court vulnerable to institutional attacks due to its penchant for meddling in political affairs, which are rightfully in the realm of executive and legislative power?
Your Honor, allow me to answer your question in this way. The Supreme Court, operates within a particular context, and the context may change, Your Honor. And so the call for the court to act will depend on the context, Your Honor. So there may be times when the court may be called upon to exercise restraint, but there may also be times when the court is called upon to more actively exercise its powers, Your Honor. So on that point, Your Honor, I think it would really depend on what is before the court and what is the context of the argument that is being presented to the court, Your Honor.
So what, in your opinion, is the value of judges exercising judicial restraint? Do you favor a liberal approach to interpreting what judicial power is in the Constitution?
Well, Your Honor, my personal bias, Your Honor, would be civil liberties and human rights. And so I personally, Your Honor, my personal bias is a more...
Being formerly a member of the Supreme Court family.
Well, Your Honor, when I was working with the court, Your Honor, I was not in the adjudicative aspect of the court. But again, Your Honor, my personal bias on civil and political rights and human rights, Your Honor, would be that the court be more progressive in terms of its actions and its decisions. But in relation, Your Honor, to other issues, Your Honor, I believe there are grounds for the court to exercise judicial restraint, Your Honor.
Now, in your opinion, Attorney Te, has this court in the last 3 decades exhibited activism or restraint in examining constitutional questions such as those now before us?
There are, I might call it, Your Honor, peaks and valleys, Your Honor. There were certain decisions where this court, exercised activism, again, given a particular set of facts. As for example, Your Honor, I think it has been mentioned before, David versus Arroyo. There have also been instances, Your Honor, when the court did not take action when, again, I speak personally, in my opinion, the court could have acted.
So would you please indulge this court to draw a line when a court exhibits judicial activism and when a court has become politicized? To this end, would you agree that judges tend to be political, especially when they are confronted with questions of policy?
Well, Your Honor, I would not be so presumptuous as to draw the line. I would point to the Constitution, Your Honor. Article 8, Section 1, Paragraph 2, particularly the last portion, Your Honor, grave abuse of discretion. I think that is a standard that is well known to the court, and that is a standard, Your Honor, that the court has applied repeatedly. There are various tests that the court has used, Your Honor, in relation to its power under Article 8, Section 1, Paragraph 2. I believe, Your Honor, that would be a line. It may not be the only line, but it is one very important line because it is what the Constitution has drawn, Your Honor. So I believe, Your Honor, if the court is looking for a balance, as it were, when it should go against or it would be more political or when it would restrain itself, Your Honor, I think the Constitution has written that line. And that line would be grave abuse of discretion, a showing of grave abuse of discretion on the part of a branch, instrumentality, agency, or government, Your Honor.
Now, this is a personal question. You can answer or not, Attorney Te. Why did you leave Supreme Court family?
Your Honor?
Why did you leave?
Your Honor, 2018, Your Honor.
Why?
Well, I believe that my work here had been done, Your Honor.
Okay. So the judiciary has time and again been embroiled in skirmishes with Congress and the executive. Questions on fiscal independence of the judiciary and even impeachment of this court's members have become rather common in the last decade or so. Is there a relationship between the attitude of this court towards judicial review, both constitutional and administrative in nature, and its dealings with the 2 other branches?
Well, unfortunately, Your Honor, impeachment is a political tool, Your Honor. And it is a tool that is also a constitutional measure that is provided in the Constitution. And unfortunately, Your Honor, politics being politics, Your Honor, it is defined by the person who wields the tool. So if you were to ask me, Your Honor, whether there is a relationship, again, it depends on the one who is wielding the tool, Your Honor.
Now, let's move on to the violation of fundamental rights. In the hierarchy of rights, would you place freedom of expression above the rights to peace, safety, and security?
Your Honor, that is what the court itself has said, Your Honor, that freedom of expression occupies a preferential right. In fact, it is oft repeated as to be perhaps be canonical already, Your Honor, that as for example, when a law transgresses on its face a right like freedom of expression, then it comes before the court bearing a heavy burden of unconstitutionality. And the burden is not on the petitioners, it is on the state.
Okay. Now, would you agree with me that advocacies, protests, and other exercises of political and civil rights which actually causes death or physical harm is different from said acts which are intended to cause death or physical harm?
Certainly, Your Honor. There are acts that even if they are defined as rights, if these acts would already transgress, Your Honor, into what the penal law would define to be an offense, whether a felony or special crime, then yes, certainly, Your Honor.
So relatedly, intention can be gathered and surmised from the attendant circumstances surrounding such exercise of political and civil rights, correct?
Yes, Your Honor. The intention is generally inferred or divined from the overt acts that are performed, which overt acts would be defined, Your Honor, into either a felony or a special law.
And that if this exercise of political and civil rights are intended to cause death or physical harm or endangers a person's life or creates a serious risk to public safety, it will fall under acts of terrorism under Section 4, correct?
That is how Section 4 defines it, Your Honor, but we disagree with that, Your Honor.
If, for example, an individual during a rally protesting against a legitimate cause went on the stage with a megaphone, started to chant, encouraging other individuals present to cause destruction to public property. In the foregoing instance, is the individual violating Section 4 or Section 9 of the ATA?
Well, Your Honor, that is one of the nuances in the law that is unclear, Your Honor, because it looks like it may, based on how you gave the facts, Your Honor, it looks like it may be a Section 9 violation, but at the same time, Section 9, Your Honor, cannot be committed without Section 4.
If the individual with the megaphone does not directly take part in the acts of destruction, would his acts constitute terrorism under Section 4 or Section 9 of the ATA?
It would be Section 9 because Section 9 makes it a specific element that the person does not take part, Your Honor.
Now, if instead of acting on the speaker's directives, the other individuals present started booing the speaker and heckling him off stage, did he commit a crime with the attempt to encourage the destruction of public property?
Well, Your Honor, I think we would have to look at the effect of the booing or the heckling, because the last part of Section 4, for example, Your Honor, the purpose, context, nature, would refer to very specific parameters, Your Honor. Was there fear, intimidation? Was there undermining of government? And so that would have to be interpreted within that particular context, Your Honor.
Now, the Section 4, you attack the provision as void for being vague, as it punishes intent, nature, and context. Among the key arguments raised is that intent is a state of mind, that law enforcers would not be able to determine one's intent to commit the acts punished. Are there other crimes in our jurisdiction that punish the intent of a person?
There are none, Your Honor. The crimes that I am aware of, which would include felonies, Your Honor, punish a specific overt act where an intent is prescribed or an intent can be inferred or divined, Your Honor.
Precisely, like Article 172, falsification by private individuals,
Yes, Your Honor.
use of falsified documents, even frustrated homicide and murder punish an intent to kill.
Yes, Your Honor.
On contrast to physical injuries.
Yes, Your Honor.
In these instances, the law likewise punishes a state of mind, but this does not by itself make the law vague as to lack comprehensible standards that men of common intelligence must guess at its meaning or lead to an arbitrary flexing the government's muscle, right?
No, Your Honor, they do not, because it is pretty clear what is being punished, Your Honor, and why it is being punished.
So can the determination of the intent and the purpose of the suspect be left to the judges in the individual cases filed before them?
Well, Your Honor, that is the work of the judiciary, unfortunately. But what is more disturbing here, Your Honor, is that the determination of the intent and the lawfulness of the act that is being performed, Your Honor, is being left at the first instant to law enforcers, Your Honor, without discernible standards. And that is where the danger comes in. Because a law enforcer, Your Honor, taking a look at a particular situation may arrive at one conclusion. Another law enforcer looking at the same situation, Your Honor, may arrive at a totally different conclusion. And so, Your Honor, it would be a case of your opinion is as good as mine. But, Your Honor, for purposes of criminal law, for purposes of constitutional law, that would not be acceptable, Your Honor. That is where the vagueness comes in.
So,
and if I may also add, Your Honor, that is where also the problem of overbreadth comes in, Your Honor, because it may include, from the point of view of the law enforcer, a legitimate lawful exercise of a right.
So do we not have sufficient standards under the rules of court and jurisprudence jurisprudence that provide guidelines in assessing intent?
Unfortunately, Your Honor, the law must be complete in itself. The law must provide for the standards. The law does not, Your Honor. The law simply says in Section 4, acts intended to, Your Honor, and that is a whole universe of acts, Your Honor.
Thank you, Attorney Te.
Thank you, Your Honor.
Thank you, Chief.
Justice Rosario, do you have some question? Okay. We will finish the interpellation so far as the petitioners today. Okay.
Hello, Mike.
Hello.
Good afternoon. We are now on the third day of this third or fourth week, rather, of okay. I think this is good enough. Okay, tama, this is better. Okay. Of the oral arguments on the anti-terror law, and there's still much work to be done, I suppose. I have prepared my questions in advance and have written them down to help us save time. Okay. Now I will just read my questions and the points I want to raise to expedite and accelerate the proceedings, at least insofar as my interpellation is concerned. I guess this will also prevent me from deviating from my desired topic. Now, since I am second to the last in terms of seniority, most of the questions, or if not all, have already been asked. So, also in deference to the request of our chief, who earlier requested us to try to limit our questions to those questions that have not yet been raised previously or earlier. But I will try my best to accommodate his request in that regard. Okay. So may I request Attorney or Congressman Colmenares to please step up to answer my first question. I'm not really sure, Congressman, if this is one of the topics assigned to you to discuss before this court in support of your petition, but nonetheless, you can ask any of the counsel to, you know.
I can ask them, Your Honor.
Oh.
And also, Your Honor, I'm not feeling quite well. I feel
Ganun
busy.
ba? Di
But
ba na lang?
anyway, Your
Sige
Honor,
na.
I'll try
Because
my
I
best.
can ask the other.
try my best.
Sige, try mo natin. Ha? Yeah, because I really would like to hear the inputs coming from other counsels. So that we want to hear also the justices of this court, what they have to say, or for them to allow them to say their piece on the issue. Now, you mentioned earlier in the course of your the interpellation conducted by one of the justices that the problem is not really, or that the solution to the problem rather is good police work and not the passage of this anti-terror law, which is that is the solution to the problem caused by terrorism.
Your Honor, that is one solution, Your Honor. But I'm saying, we are saying, Your Honor, that even if we need a law, that law cannot be allowed by this court that is of unbridled discretion, that is vague and overbroad, Your Honor, because that that is the issue before this court, the constitutionality of this law.
Okay.
So whether or not they implement it, if some of the opinion they will implement it without abuses, some of the opinion that they will not implement it or without abuses, the issue before this court is actually whether that law violates the
Okay,
Constitution.
Congressman, you
Your Honor.
stated that
Thank you,
earlier
po.
already.
Thank you,
No
po.
need to elaborate further on that point, I guess. Now, the way I see it, Congressman, terrorism is a much complex crime, requiring, as it does, some elaborate planning, precision timing, perfect execution, and a vast network of conduits and accomplices to carry out. It is nothing compared to the more common crimes as murder, theft, or robbery. A fine example is the 9/11 attack in US, which from media accounts was successfully launched because of the painstaking planning and the unexampled commitment of the perpetrators. Given the terrorist commitment to succeed and considering the elaborate planning, the furtiveness of the preparation and execution, and the damage that it causes, as explained by Justice Javier last time, don't you think that the authorities should be given some more slack in dealing with it? After all, it is not a simple conspiracy that can be discovered overnight or with little time at all, like in other common crimes, and the perpetrators or conspirators brought to justice because of some timely sleuthing skills. Terrorism is nothing near murder case in magnitude. Now, in this aspect of the crime, sir, don't you think some leeway may be given to the authorities to conclude their investigation and bring all perpetrators and conspirators to their knees? Isn't this the very purpose of the 14-day detention of suspected terrorists by virtue of a written authorization to ensure that terrorism, as much as possible, is eliminated at its very core? The 14-day detention period, if I may conclude my question, sir, in my opinion, is, after all, a valid exercise of congressional prerogative, as earlier discussed, to extend the periods in Article 125. Isn't said period reasonable given the difficult task given to police and military authorities to weed out terrorism? You may now answer.
Thank you, po. They can even claim that, Your Honor, we need more tools. But we are saying that even if we question, draconian nga sabi ko yung HSA, it's already allowed po in HSA. The surveillance, the monitoring, the freezing, the opening of bank accounts, they can even arrest a suspect, Your Honor, without warrant. So a foreign terrorist coming over and they're pretty more or less confident that he or she is a terrorist, they can do that under HSA. So their argument, Your Honor, that we need the ATL because we don't have the tools to ferret out these crimes is actually wrong, Your Honor, because they were allowed by various laws, terrorist financing laws, there's even the chemical and nuclear weapons laws, and so many other laws under the revised penal code, Your Honor.
That was quite impressive, Congressman. Now, moving on to another point. There is an apprehension that the anti-terror law is going to be used as a tool for political persecution. Right? Okay. Is this true, Congressman?
Well, it can be used, Your Honor, because
is
they
one of the issues
eliminated
raised.
the safeguard that the terror law cannot be suspended 1-2 months before election and 1 month after. So it can really be used now because they eliminated that provision, Your Honor.
Now, as I gathered in the previous interpolations and the response made by the Counsel for Petitioners, they advanced the argument that since the members of the Anti-Terror Council are men serving at the pleasure of the President, the say-so of the latter may prove to be the lone basis for the granting of the written authorization to detain an individual, regardless of whether or not there is indeed basis to hold him for the commission of some terroristic acts. In other words, Congressman, there is fear that the anti-terror law might be used not exclusively to deter terrorism, but to silence government critics, which would be possible if members of the Anti-Terror Council would engage in partisan politics and connive with the ruling power for the purpose of effecting groundless arrests and detentions to advance their political agenda. Am I right, sir, that this is precisely one of the arguments against the wisdom of the anti-terror law?
Other than the fact that the law is unconstitutional, yes, some people have raised that, although the main issue is constitutionality. The track record of the ATC, red tagging, terrorist tagging, Caritas Belgium, Swedish Red Cross, so many activists, even universities, only shows that they are really a dangerous group, Your Honor.
Okay.
And we are not speaking from a lack of experience. We have seen the abuses, Your Honor. But I would like to stress, whether or not, because this can be contentious, they will not abuse, we will abuse. We have always been saying that it's the unbridled discretion. Can they arrest me? Arrestuhin mo nga si Colmenares. Sir, wala naman tayong ebidensya. Di bali na. Pag nag-bail yan, i-restrict lang natin yan sa munisipyo kung saan siya na, i-house arrest natin. Di tapos. Diba? They can use that, Your Honor.
Please try to limit your response
Yes,
to
sorry, Your
to
Honor.
the
Yeah,
topic
yes, Your Honor. Thank you po.
Propounded by this representation, please.
Opo.
No, but there are other factors that would seem to negate these apprehensions. First, this was earlier discussed, there is the presumption of regularity in the performance of official functions, jurisprudentially established as an aid to the effective and unhampered administration of official function. In fact, Congressman, it is said that without such benefit, every official action could be negated with minimal effort from litigants, irrespective of merit or sufficiency of evidence to support such challenge. Now, this is my question, sir. Can we not extend to every written authorization the same presumption of regularity, considering that this benefit is also being observed in all other areas of government administration?
That is the problem here, Your Honor, because all their acts have now the presumption of regularity. As I mentioned, Your Honor, there is even no need to really violate the rights of the suspect, because the law actually makes it legal and lawful for them to violate, like freezing or opening bank accounts or house arrest. So, Your Honor, while when they do that later, if this terror law is passed, there will be a presumption of regularity, and even our habeas corpus, even our writ of
I'll try to be more specific. Sorry to.
Opo.
Do you suppose, Congressman Colmenares, that the council members would participate or connive with military or police authorities in carrying out an injustice or violation of the law? The presumption that public duties are being performed in a regular and legal manner has been adopted for a reason, one of which is that penalties prescribed for wrongdoings on the part of the public official is more serious, as they have been given the public trust and thus should remain faithful to their sworn duties to retain confidence reposed in them by the public. I would say that it would have been different, Congressman, if the task of determining the presence of these conditions were made to be undertaken by the military and police authorities, in which case we could expect a possibility of a farce or a false declaration of the presence of such conditions. However, for the council, Congressman, to participate in an outright and blatant subordination of their duties is, to my mind, a bit of a stretch. How do you see it, Counsel, from your viewpoint?
Thank you po. Yes, well, the track record itself, Your Honor, shows. They have publicly announced I'm under surveillance. They have filed cases against me. Imagine, Your Honor, for kidnapping. Kidnapping, Your Honor.
Okay.
And crimes against humanity and so on. They have filed cases against many activists. They have red tag, as I mentioned, almost all sectors of life. So what was the purpose there? For us, Your Honor, it strikes a firm conviction that they will actually use this not for the terrorists,
And you're talking
really.
from personal experience.
Yes
Congressman.
po. And also, as I personal knowledge din in a sense, others, Your Honor. But as I would like to reiterate, the issue here is the fact that this law is unconstitutional and they're given unbridled discretion to use it on a maute or a colmenares,
Okay,
Your Honor.
I'll raise another point.
Salamat po.
Still on, the council, medyo importante po yan. There is another seemingly valid point. Again, in my opinion lang yan, Congressman.
Opo.
Is there anything in the Anti-Terror Act that would exempt members of the Anti-Terror Council from administrative or even criminal sanctions should they issue a completely baseless written authorization? If there is none, wouldn't sanctions or penalties like those imposable for perjury or under the Anti-Corrupt Practice Act adequate deterrent to prevent council members from issuing bogus written authorizations?
I couldn't imagine of any, Your Honor, because Section 4...
Wala.
No, Your Honor, because Section 4, they will always say, well, that's a bias against me. No, we believe kasi you're a suspect intending to interfere.
Okay.
So it's very vague and overbroad that they have a color of legality there in the sense that whatever you do, the law already empowers them to do that. So what can you do, Your Honor?
Okay, let's put it like this. Supposing, Congressman, that a member of the council, in connivance with military or police officials, falsely proclaim that the conditions mentioned in the Anti-Terror Act have been met, and that henceforth the person to be arrested may be detained for 24 days without formally being charged in courts. Is that council member exempt from prosecution for perjury and other crime, like perhaps arbitrary detention? Is there anything in the ATA that so exempts such council member? Or in other words, does the ATA or the anti-terror law encourage or at least tolerate the commission of perjury and arbitrary detention as a means of perpetuating political persecution? What is your take on that, Congressman?
Yeah, well, Your Honor, we can file, of course, a case for perjury, but they will say, well, the law says so that he is a suspect. How do I prove that I'm not a suspect, Your Honor? It's very difficult for me. Can I gather any evidence that they surveillance me or something? But the law allows them already, Your Honor. In fact, it's confidential. So maybe the law will allow you the right to file it, but the remedy is no longer effective, but is illusory, Your Honor, because the law has practically legalized the violation of rights, Your Honors. So I guess if the question is, can we file a case of perjury? Yes, definitely, Your Honor, but how do you even prove it when the law has actually allowed them untrammeled discretion to implement that, Your Honor?
The provisions about this, you're questioning the validity of provision for allegedly being violative of the section, yes. Right to travel, something like that.
Opo.
The right to bail and
Yes.
in detention incommunicado.
Yes, Your Honor. Yeah.
Is that still big, sir? Yes, tell me.
I didn't hear, Your Honor. Again, please.
Kasama po ba yan sa assigned topic nyo, Congressman?
Yes, insofar as,
Okay.
yes, Your Honor, it's one of my topics, but it's divided among many.
O,
But
sige.
yeah, Article 34.
Kayo na po para mas mabilis, ha? Just to fast track the proceedings. However, Congressman, it appears that travel restrictions under the ATA in the form of a whole departure order is to be imposed by the court upon a showing of probable cause. Tama po?
The whole departure order po, yes.
So as in cases where the evidence of guilt is not strong, the limitation of an accused movements to the city or municipality where he or she is residing or the venue of the offense is subject to the court's determination in the interest of national safety or national security or public safety, I'm sorry. In fact, the court may even leave or deny the application to limit an accused movement as it is provided that travel outside such city or municipality may be allowed if authorized by the RTC. Now, this is the question, Congressman. Doesn't the intervention of courts in cases like these constitute valid safeguards against apprehensions that the right to travel is being impaired? Doesn't the Constitution itself provide that the right to travel may be restricted in the interest of national security, public safety, or public health? Because as you know, Congressman, the liberty is not absolute. You did mention that earlier. And thus, doesn't the ATA, in providing for travel restrictions, if required only by national security, to be determined yet even by the court, is in fact fully cognizant of the constitutional provision on the right to travel? Your answer, sir.
Well, in the first place muna, Your Honor, the issue of restriction to the rights of travel on national security grounds, for example, is founded in the Constitution. But in this case, the evidence of guilt is not strong. So what is the basis of the ATC in detaining me in the municipality where they filed the case? They don't have even the basis to do that because the evidence of guilt is not strong. So in that sense, Your Honor, it's baseless. And secondly, I'm not even sure if the court has discretion because the law says the court shall restrict the travel of the accused upon the application of the prosecutor. So it's not even clear to me, Your Honor, does the court have the discretion? The law says the court shall restrict. And in fact, if you look at the IRR, Your Honor, it granted so many powers to the ICC, to the ATC, not in the law, Your Honor. And in this case, they even made it sure that the court shall order the house arrest of a person upon the application.
I guess that would be enough.
Thank you po. Thank you po.
One more question.
Salamat po.
Okay ka pala, kayang-kaya mo sagutin. If, for example, Congressman, the law should prohibit an accused under house arrest of, say, communicating with the outside world via any means available, but such restrictions may be overturned by the order of the court. Now, Congressman, do you suppose that there is still violation of the constitutional provision against in form of detention? Would denying an individual who has been placed under house arrest by a competent court access to communication still be considered as an incommunicado form of detention? And my last question is this. May I ask the petitioner, of course, you're taking up the cudgels for petitioners, Congressman, what is your concept of incommunicado?
Yes, Your Honor. Well, we did say in the petition, it is akin, Your Honor, to the incommunicado detention. The first reason, Your Honor, why it's still violative of the Constitution, other than the vagueness and the overbreadth of the law, of which I am suspected, but now the evidence of guilt, even in such a vague and overbroad law, is not even sufficient. Even if it's broad ng ang batas, hirap pa rin sila mag-produce ng ebidensya. Ngayon, nasa house arrest po ako, it still violates. And the fact is, I have to ask permission from the court na i-afford ako na mag-communicate. Why? Why, Your Honor? Why should I ask? Why should I be given with the burden of doing that, Your Honor? When I was granted bail and the evidence of guilt is not strong, Your Honor. So parang overreach na talaga ito, Your Honor, in the sense na ang hina nga ng ebidensya nyo eh. Wala nga kayong basis for national security or public safety eh. Tapos, i-house arrest nyo My God, Your
Okay,
Honor.
Congressman.
That's really
That would
too
suffice.
much
Thank
po.
you very much for the
Salamat po.
very impressive discussion on that topic or subject matter. May, last question na lang po, Chief, para kay Congressman, isang Congressman naman. Congressman Lagman.
Salamat po.
Thank you po, Congressman. Good afternoon po, Kong.
Good afternoon,
In the
Your Honor.
second paragraph of Section 29, okay ba kayo? Section 29, sir?
Yes, Your Honor.
Okay, good. The arresting or apprehending officer is mandated to inform the judge nearest the place of arrest or apprehension of what? The details pertaining to the arrest, correct? Sir?
Yes, Your Honor.
Okay, good.
That's the provision of the law.
Yes po.
But it will be noticed that that notice is not even under oath. The law does not require that the notice
That's so.
to the
You're a
judge
keen
should be under
observant,
oath.
Congressman. I did not see that. Anyway, thank you for the information. I will continue. Proceed with my. Now, well, Congressman, what do you suppose is the purpose of the notification?
Well, that is supposed to be a safeguard.
Okay.
But if we compare that to the Human Security Act, that safeguard is actually so nebulous. Because under the National Security Act, the suspect should be brought before the judge,
okay,
so that the judge can determine the identity of the captors and the suspect. The judge can also determine why the suspect has been arrested, and also to determine whether the suspect has been subjected to torture.
I'll now go to my next question, with your permission. Now, upon being notified of such arrest or apprehension, Congressman, what do you think at that point are the remedies of the arrested individual, and what courses of action, if there's any, may the judge take under the circumstances?
Well, under the circumstances, Your Honor, if the ATA is not declared unconstitutional, more particularly Section 29, then the remedies of the detained suspect would be illusory and theoretical. Because
why is that, Counsel?
He could apply, for example, for habeas corpus, but then the ATA or the enforcing agent will always say there is a legal cause because there is an authorization from ETA.
Sige.
Then he could not even apply for a writ of amparo because it's the same reason.
Okay.
The
Congressman,
detention is supposed to be legal until Section 29 is declared unconstitutional.
it is also required that the Commission on Human Rights be notified of such arrest or apprehension. Now, this is my question. Don't you think that under these circumstances, sufficient safeguards have been afforded the arrested individual to militate against any violation of his basic human rights, considering that he or she at that point is given the right to consult or be seen by his counsel?
The notification to the Commission on Human Rights, Your Honor, is not an adequate safeguard.
Okay. Now, do you think Section 29 does away with the provision of the law on warrantless arrest? Does it authorize warrantless arrest on mere suspicion alone that the person to be arrested has committed an act punishable under the Anti-Terrorism Act? Or is it required that before an arrest is made, an act punishable under ATE has just been committed or is being committed, and there is reasonable ground to believe that the person to be arrested is responsible for it?
It appears, Your Honor, that the intention really is to create another instance of warrantless arrest. But in a case of warrantless arrest, Your Honor, the arrest is not made on mere suspicion. because the arrest is made because of implug delicto or because of flight or because a person has escaped from detention or from a penitentiary. So in this particular case, the fourth instance of warrantless arrest, aside from being not consistent with the three other instances, it also amends the rules of court on warrantless arrest. And the Congress cannot do this because the power of the Supreme Court to promulgate rules protecting constitutional rights is exclusive and it cannot be interfered with by the Congress.
I'm about to wrap up, Congressman. Okay ba kaya kabasa Section 27? One last question na lang to. It's already
Yes, Your
gone
Honor.
beyond the time allocated for my
Yes, Your Honor.
interpellation. Sabi nila, yun daw section, yung anti-terror law, specifically Section 27 thereof, which deals with what? Preliminary and permanent order of restriction. This is being questioned on the ground that it supposedly is an ex post facto law or a bill of attainder, as it purportedly punishes mere membership in an organization. Correct? Now, correct, sir. Tama po, no? No.
Well, that has been challenged by the other petitioners,
Yes,
Your
po.
Honor.
Now, Section 26 is very similar to the Anti-Subversion Act, which, as you know, has already been repealed.
Yes, Your Honor.
In the sense that both could be regarded as so-called conspiracy statutes. Okay?
Yes, Your Honor.
Before its abrogation, this court, not the present court, of course, decided a number of cases upholding its validity, foremost of which, and I'm pretty sure that you are very familiar with this, is the 1972 case of People versus Tayag. Are you
Yes, Your
familiar
Honor.
with
Yes, Your
that
Honor.
case, Kong?
Yes, Your
Okay.
Honor.
Now, wouldn't you say, sir, that the ratiocination or the holding of this court therein, meaning in that case, could still be applied to the present petition, specifically with regard to the issue on whether or not it is a bill of attainder? And considering the allegation that it is an ex post facto law, sabi ng mga petitioners, mga abogado, will you please point out the provisions in the law that would indicate that the Anti-Terror Act may or should be applied retroactively to touch on past activities that would otherwise fall within the ambit of terroristic acts as defined and described in said law?
Unfortunately, Your Honor, with due respect, my petition did not question the ATA as being a bill of attainder or an ex post facto law. But the other petitioners did, and I subscribe that they would be able to defend their position very well.
I'm sorry to have directed the question to the wrong counsel. Anyway, it's already 6 p.m. That's my... thank you very much, Chief.
Okay. So the last to interpolate is...
Congressman, salamat po.
Thank you.
Justice Lopez. Joseph.
Very few questions. Congressman Lagman, huwag na po kayo umalis. Ayaw ko pong napapagod kayo. Now, in as much that I am the most junior and supposedly the last to ask questions, I thought I'm given as much leeway to ask as many questions. But it's not the case. So I'll try to limit myself to several follow-up questions, Congressman. Now, first, I heard you were saying earlier, you were quoting paragraph, can you hear me better, Congressman?
Yes, I can hear you well, Your Honor.
Now, you were quoting a part of the constitutional provision found under the last paragraph of Section 18, Article 7, which provides that during suspension of the privilege of the writ, any person thus arrested or detained, shall be judicially charged within 3 days. Otherwise, he shall be released. Now, wouldn't you say that this limitation only applies in situations outlined in the Constitution and not in all instances of detention?
We submit, Your Honor, that is an omnibus protection to all those detained under any and all kinds of crimes. But what is important to underscore, Your Honor, with respect to Section 18 of Article 8, is that if during times of emergency, a person cannot be detained for more than 3 days without being delivered to the judicial authority or released, then with more reason, during ordinary times like today,
Now,
any detention of 24 days under the ATA is really unconstitutional. It's odious. It is even cruel.
Now, Congressman Lagman, let me refer you into the records of the Constitutional Commission of 1986. I would like to read the response of Commissioner Padilla during the CONCOM of 1986, where it was clearly manifested that the intention of the provision was to be restrictive. And I quote, "It is true that under Article 125 of the Revised Penal Code, which penalizes the delaying of the transmittal or delivery of the person arrested to the judicial authorities, the period is based on the gravity of the offense, and this is punishable by the same penalties as those for arbitrary detention under Article 124 of the Code and the delay in the release under Article 126. But this provision," he was pertaining to Section 18, Article 7, "is made to apply only when there is a suspension of by the President of the privilege of the writ of habeas corpus." So it covers a different situation from that contemplated in the Revised Penal Code. So, quote unquote, would you like to comment on this, Congressman Lagman?
Yes, Your Honor. My interpretation of that statement of Commissioner Padilla is that this provision is applicable only when the writ of habeas corpus is suspended. But it does not say that it is applicable only to rebellion or to acts relating to invasion. And moreover, this court has held in several instances that the opinion of a constitutional commissioner is not controlling. That is his personal opinion.
But this is part of the records of the Constitutional Commission. It was quoted from the statement that this detention limitation is only applicable during times when there is suspension of the writ.
That is correct, Your Honor.
And besides, the law on Article 125, 124, and 126 are part of the laws of the land, and no one can deny that the Congress may change the law as they please. Mr. Congressman, is it not the case?
In the first place, Your Honor, let me just repeat that the statement of Commissioner Padilla is limited to the fact that it is implementable when the writ of habeas corpus is suspended. But it does not say that it does not cover all and any crimes during that period. Number two, the Congress does not have unlimited power to amend laws, particularly so when the mandatory law is challenged to be unconstitutional. For example, Section 29 cannot amend the particular article in the Revised Penal Code because Section 29 is irremediably unconstitutional because it substitutes executive warrant to judicial warrant. It substitutes suspicion to probable cause. And there are no standards by which the ATC would exercise its power to give a written authorization for detention, which includes the warrant to take a person under custody, because there can be no detention without arrest and custody.
But Congressman, is it not clear that under the implementing rules issued by the DOJ, there was they were not talking about warrant of arrest, but it is about warrantless arrest. But I need not go into that because it has been explained earlier already. Now, anyway, going to another topic, since under time constraint, and I promise I'll be given only about 10 to 15 minutes to finish all my questions. Now, does designation amount to a declaration that a person is a terrorist? This can be found under the ATA law. Is it designation, is the designation made by the council a declaration that a person is already a terrorist?
Effectively, Your Honor, one who is declared under that section, whether a person or an association or a group of persons, would be subsumed under an accusation that one is a terrorist.
Is it not the case that they will have to undergo an application of proscription filed by the DOJ and only upon the authority of ATC and recommendation of the National Intelligence Coordinating Agency before a person can be declared terrorist, and not a declaration by the ATC alone?
Application for prescription is discretionary on the part of the ATC. It may or it may not apply for prescription. And if it does not apply, then its designation stands.
Well, again, Congressman Lagman, sir, under Section 6.9 of the Implementing Rules and Regulations of the ATA law, a person designated by the ATC as committing acts of terrorism may apply for the listing within 15 days from publication on several grounds. Given the recourse of the listing, would you agree with me that designation will not really create a threat to the rights of a person?
Your Honor, the issuances under the implementing rules and regulations cannot amend or modify the law. It could not even rectify the mistakes in the law. It cannot improve the law, Your Honor.
Well, going to another topic before my time is up, Congressman Lagman, you mentioned also about a certain case. This is Dicini versus Secretary of Justice. I don't know if it was you who mentioned it earlier. Section 12 of the Cybercrime Prevention Act, which empowers law enforcement authorities with due cause, let me repeat that, quote unquote, with due cause, to collect or record by technical or electronic means traffic data in real time, was declared unconstitutional by this court, and the phrase with due cause was declared by this court as too sweeping and lacks restraint, for it lacks reference to the probable commission of a particular crime. Now, unlike the Cybercrime Prevention Act, would you agree with me that ATA contains sufficient safeguards to protect a person's right to privacy insofar as the collection of data is concerned?
I would like to submit, Your Honor, that the safeguards provided for in the ATA are virtually motherhood safeguards. And I would like to amplify this statement in the memorandum I would submit before the Honorable Court. I would like also to say that the essence of the Sini versus Secretary of Justice is that there is an exception to the rule that penal statutes cannot be facially challenged. In this case, a statute can be facially challenged if it is challenged as an abridgment of the freedom of expression and of the press.
Now, let me enumerate some of the safeguards, Congressman Lagman, sir. Section 19 in relation to Section 17 of the ATA law, which requires judicial authorization of the Court of Appeals or from the Court of Appeals. And this was mentioned earlier by my esteemed colleague, Justice Javier, that it's composed of, a division is composed of 3 justices and all of them must concur. And this will be effective for a period of 60 days, renewable for another 30 days. And with it, the requirements of probable cause before the state may be allowed to secretly wiretap or collect data from those charged of committing an act of terrorism. Now, there is a reference to a particular crime, unlike other laws, particularly under the Cybercrime Prevention Act, and there is a requirement of probable cause. Are all these safeguards insufficient from your point of view?
Your Honor, those may be specific safeguards which we could appreciate, but we should underscore here that it gives prolonged duration of watching or searching evidence against a suspect. I suppose, Your Honor, those safeguards are diminished because of the prolonged period which may be awarded to the enforcement agents. Again, we are going to amplify this in our memorandum, Your Honor.
Thank you, Congressman. Now, assuming that communication or data of a person charged or suspected of committing an act of terrorism is obtained by the state, would that person lose reliefs intended to protect his or her privacy, such as a petition for a writ of habeas data for the destruction of data obtained by the government, or the right to remove or destroy data concerning false personal information pursuant to the Data Privacy Act? Can you explain,
Your
Congressman
Honor,
Lagman?
in this advanced stage of technology, there are those who submit that the right to privacy is really a very superior right. And for this reason, there is need to really give ample protection to the right of privacy.
Now, talking about privacy, Sir, Chief, can I ask for an extension of 5 minutes?
Yes, of course, you can have another hour.
Now, let us go to the concept of surveillance vis-a-vis the right to privacy. Now, pursuant to Section 16 of the ATA law, in Gamboa versus Chan, this court has held that when the right to privacy finds tension with a competing state objective, the courts are required to weigh both these notions. The right to privacy may thus succumb to an opposing or overriding state interest deemed legitimate and compelling. Would you agree with me that the proposition that the right to privacy must give way in order to curb threats of terrorism?
Your Honor, to a certain extent, I would agree, but I would submit, Your Honor, that the compelling state policy should be tested with strict scrutiny so much so that if there can be other means of implementing that policy, which is less stringent and less violative of the right of privacy, then that should be done.
Now, Congressman Lagman, you mentioned about strict scrutiny. I think this is concept adopted by the U.S. Supreme Court. But let me refer you and let us borrow from another country's experience. The method of intelligence gathering via wiretapping and intercepting communication was a crucial component in USA Patriot Act of 2001, which was enacted right after the advent of the September 11 attacks on the Pentagon and the World Trade Center. These provisions have been credited for the success of hundreds of anti-terrorism operations since 2001, such as the thwarting of a terrorist plot on airplanes between US and UK that would have caused, and I quote, mass murder on an unimaginable scale. In fact, the New York Times, in an article dated August 10, 2006, reports that the plotters had planned to use liquids in drink bottles smuggled in hand baggage to combine into explosive cocktails aboard the flights. Thus, if agents were not equipped with this tool to monitor such communication, they would have had blood on their hands. An examination of the Patriotic Act would reveal that government is likewise given an expansive powers to be able to effectively carry out such power in recognition of the fact that terrorist operation would usually take advantage of the right to privacy. Section 2, paragraph A and B of the Act authorizes the installation of devices to record all, meaning all computer routing, addressing, and signaling information. The government is able to access this information, meaning U.S. government, to merely certifying that the information likely to be obtained is relevant to an ongoing criminal investigation. So all they have to do is to certify that there is an ongoing investigation. Unlike in our case, in the ATA law, it requires probable cause and a reference crime before you can get a permit from no less than the Court of Appeals before you can get a authorization to do those wiretapping things. Do you agree with me, Congressman Lagman, sir?
Yes, Your Honor, you are correct. But that does not diminish the fact that whatever state policy which should be implemented, what should be done by the state or in the law itself is that it should use the least invasive means of securing that policy, which would not unduly intrude into constitutional rights. Because if the state would enforce acts of terrorism against its citizen, then it would have already submitted to the terrorists their own methods, so much so that would allow the terrorists to win their battle against the state.
So in other words, Congressman Lagman, you are saying that the safeguards provided the ATA law are not enough and are not as restrictive as you want to make it appear, so that people can still exercise their constitutional rights even under the said law.
Yes, Your Honor. Compared to the safeguards under the Human Security Act, the safeguards provided for under the ATA would be one thing in comparison, despite the fact that the Human Security Act is also being challenged as not completely protective of civil liberties.
So thank you, Mr. Congressman. As promised, I have limited myself to 15 minutes, and thank you for patiently responding to to all my questions. Thank you, sir.
Thank you
Chief.
so much, Your Honor.
Before we conclude, there is a request from the, thank you, Congressman, Solicitor General, that if you are already through with your opening statement, can you furnish the court copies of your opening statement not later than Friday? Justice Rory, not later than Friday? Yes. Can you do that, Mr. Solicitor General? Wala pa ate.
Your Honor, Chief, how many days?
Until Friday. Until Friday because
Friday
of,
this week, Your Honor.
This week. Yeah.
Yes, Your Honor.
Okay, thank you.
We will do.
Thank you. Okay then. Okay.
Thank you.
So after the conclusion of the interpellation of the counsels of the petitioners, we will continue the hearing next Tuesday, March 16, to hear the arguments of the Solicitor General. March 9, I'm sorry. Yeah. March 9. Ay, may nihari kasi. March 9 at 2:30 in the afternoon to hear the arguments of the Solicitor General and the interpellation by the court. Thereafter, we will hear the position of the amicus curiae, and thereafter we will conclude the hearing. That will be all right. Okay. If there are no other matters to be taken up today, then let's adjourn the session today.